To the first joint Senate Assembly Judiciary Committee hearing. Madam Secretary, would you please call the roll?
Senator Harris. Here. Senator Hammond. Senator Robeson. Senator Ford. Here. Senator Kewin. Senator Sagerplum. Senator Brower.
Here.
Assemblyman Anderson. Here. Assemblyman Araujo. Here. Assemblywoman Diaz. Here. Assemblywoman Fiore. Here. Assemblyman Gardner. Here. Assemblyman Jones. Present. Assemblyman Nelson. Here. Assemblyman Orenshaw. Here. Assemblyman O'Neill. Assemblywoman Seaman. Present. Assemblyman Thompson. Here. Assemblyman Wheeler. Here. Chairman Hansen.
Here. Please, Madam Secretary, as they come in, mark them present, the ones that are absent. All right, folks, this is obviously a big hearing today. Few rules of the road. Make sure your cell phones are turned off or in silent mode or anything else that might make any noises. If you're going to testify, be sure you've signed up in either opposition or in favor of it or in neutral. Be sure if you represent an organization that when you come up, you present your full name and the organization you may represent. Also, if you have a business card, leave it with the secretary. I guess I should start off with this disclaimer. I am Chairman Ira Hansen. I am a licensed Nevada contractor. In fact, February, right now, it's been 29 years since I got my license. This bill, AB125, we're going to hear in a minute, will have no more or no less impact on me than any other licensed contractor. So I want to get that disclaimer out there. Also, if you have any handouts that you wanted the committee to see, if you wanted to place them in Nellis, they had to be turned in yesterday by noon. However, if you'd like, you have to have at least 20 copies to share with everybody. A few rules of the road for those of us on the committee. What I'm going to do today is I'm going to allow a 1-hour period for the proponents of the bill to present their information. I will grant an hour in opposition. I will then allow both sides to come back up briefly for any rebuttal that they may want to have. When you come to testify, other than the first of all, I'm going to have at least, if we can load up all 4 chairs, that's great. I'm going to have all 4 people testify. No questions will be asked until all 4 have had an opportunity to present it. Then what I'm going to do is allow every member of the committee a chance to ask 1 question with 1 follow-up per witness. To help expedite the process, we will end this meeting promptly at 10:30, if not sooner. So everybody needs to understand that. It's been a lot of interaction on this over the years, that's for sure. So we're going to get into it right away. But very important for decorum purposes, because this has been a heated issue over the years, we show complete respect to the people as they testify. No booing, no clapping, none of that. So we want to show a first-class presentation here today and help get this issue resolved. It's been a critical issue here in Nevada for many years now. So without saying further, I'd like to invite the proponents up to the table. First up this morning is our Majority Leader, Paul Anderson.
Mr. Chairman, thank you for the opportunity. Committee members, Assembly and Senate committee members, thank you for the opportunity, and I appreciate the opportunity to introduce AB125. With me today is Senator Farley, who has personal experience in this area, as well as we have with us, who will come up shortly, Mr. Hicks and Mr. Marquis, who are subject matter experts for this bill. I will simply introduce the bill, Mr. Chair, and turn the time over to Senator Farley, and then we'll have Mr. Hicks and Mr. Marquis come up and go through the bill line by line, if that's okay with you.
That'd be fine. Let me interrupt real quick. I forgot. I do need to officially start the meeting. This is the hearing for Assembly Bill 125, so go ahead.
Thank you, Mr. Chair. This bill, AB 25, is a bill that will bring long-needed reforms to Nevada's construction defect laws found in Chapter 40 of the Nevada Revised Statutes. Chapter 40 was enacted over 10 years ago with all the right intentions. The hope was to help homeowners get their issues fixed, their problems fixed quickly and correctly without the need of a costly lawsuit. Good intentions, however, alone do not make for good law. In 1996, a year after Chapter 40 was implemented, there were about a dozen construction defect lawsuits pending. 5 years later, in 2001, there were so many ongoing cases in Clark County alone that 3 district court justices were assigned to a so-called construction defect panel, also known as DIRT Court, to exclusively handle the ever-increasing number of defect cases. Less than 2 years later, in 2003, a special 3,000 square foot building was erected in Clark County just to handle the ever-increasing number of cases. Nevada's construction defect laws are some of the nation's worst. Current law promotes litigation, not resolution. It increases costs, not protections, and it puts the focus on lawyers, not homeowners. There's been little to no construction of family housing across the state, but in particular in my district since I was elected in 2012. When I tried to find out and ask builders and developers why that was the case, they often reference Chapter 40 as the reason, and the lawsuits as the reason why they could not build multifamily homes. And the facts appear to support their claim. Between 2006 and 2012, construction defect lawsuits in Nevada increased 355%, while new home construction over the same period decreased by 86%. Homeowners in Nevada are 38 more times likely to be involved in construction defect litigation than anywhere else in the country. Now, no one believes that Nevada leads the nation in construction defect lawsuits because our proud workers and home builders build the nation's worst homes. Something else is afoot. A recent survey of homeowners involved in construction defect lawsuits helps explain this discrepancy. Only 3% of those surveyed, the homeowners got involved in a Chapter 40 lawsuit because they reached out to an attorney. The other 97%, we either said they were solicited into a lawsuit by an attorney or had a lawsuit filed by their HOA without their knowledge. Clients are not seeking out attorneys. Attorneys are seeking out clients. The law is no longer a means to fix a problem, but to exploit a problem. 52% of those surveyed were unaware of their option to make warranty claims on their homes prior to filing a suit, and 65% got involved in a Chapter 40 case without ever contacting their home builder first. 67% found out their home was involved in a Chapter 40 case after the fact. These homeowners waited an average of over 2.5 years to have their claims resolved, and even then, only 60% actually had their home repaired as they had hoped. To understand the perverse incentives our law creates, consider the following example. In a case brought by an HOA involving 99 homes, the homeowners were awarded just over $580,000, or about $5,800 per homeowner. But the attorneys were awarded nearly $9.3 million, or just over $93,400 per home. Rising insurance premiums and the costs and risk of litigation have forced many small builders out of the residential construction entirely. In fact, small builders do 340% more residential work nationally than they do in Nevada. Chapter 40 has caused serious problems in Nevada. It harms our construction industry without providing the added benefit to the homeowners. It's time, I believe, we fix the problem. It's time to restore the original intent of Chapter 40 and make litigation a last resort, not a first resort. And I believe it's time to provide homeowners and home builders the protections they deserve. And I think AB 125 accomplishes that very well. Thank you, Mr. Chair.
Thank you, Mr. Anderson. Senator Farley, would you like to go next?
Yes, thank you. Good morning, Mr. Chairman and members of the committee. My name is Patricia Farley, and I would like to testify in favor of AB 125. I have over 17 years of residential and construction experience in the state of Nevada. I have spent several years working for home builders, commercial subcontractors, and now I own a mid-sized subcontracting firm. I serve home builders, homeowners, and commercial general contractors. Today, I employ anywhere between 40 and 80 employees. I am licensed in the state of Nevada and in California, and I am a certified woman-owned business. I started my construction career in home building and was at the front and center of the rise of the construction defect. in the home building industry. I worked for the declarant, so I had a front row seat to the HOA companies working well with attorneys, rallying homeowners with the battle cry of construction defect. The thick relationship between the HOA companies and certain law firms was palatable. I saw homeowners lose the value of their homes, not have defects or construction errors addressed, and the only one to prosper in this relationship was the specialized construction defect trial attorneys. Today, as a business owner, I make the decision about which jobs to take solely on the potential for litigation to ensue. This means I turn down good work, don't hire employees, and I don't increase the skill set of my workforce purely because the chance of litigation for performing that type of work is too high. I can't afford the attorney fees, my insurance rates go up, and I have to hire additional staff to handle all the paperwork associated with this litigation. So I pass on good opportunities every day. With the above said, excuse me, the most important part of my testimony is I am a business owner and I do not take or perform certain types of work simply because the likelihood of litigation to ensue is so high and so costly. I reject the opportunity and the associated benefits to my business and my employees, and this is wrong. I am in full agreement that construction defect and errors must be immediately addressed and resolved to code. I fully agree that customers need an effective and efficient manner to resolve these issues, but they need their issues resolved. With that said, the rise of construction defect and the continuation of the current laws in the litigious environment hurts Nevada. The magnitude of the problem is remarkable. Between 2006 and 2012, years I served both in the home building and the subcontracting industry, construction defect lawsuits in Nevada have increased by 355%, while new home construction over the same period is down 86%. Nevada's housing market and industry is lagging, to say the least, in the recovery. The enormous and outrageous costs associated with the current laws prevent builders from diversifying their housing stock, which eventually puts housing out of reach for a number of rising earners, retirees, and leaves little to no options for younger workers in our state. Builders and subcontractors are terrified at the rate in which we get sued for defects. I believe that AB 125 makes substantial fixes to Chapter 40 and will accelerate job creation in the housing sector. Simply getting housing back to pre-boom levels would add nearly 40,000 jobs throughout Nevada and generate at least $336 million in new tax revenue annually. This type of employment would be approximately equivalent to bringing 2 to 4 Teslas factories each year. I believe AB 125 narrows the definition of construction defects such that attorneys specializing in this type of litigation are not incentivized to mislead or misrepresent claims of defect. I am in favor of Section 2, the language of indemnification. I also believe that AB 125 encourages construction of well-built home. It incentivizes builders to diversify their home options to include condos, attached homes, townhomes, etc., all the options that young earners, first-time homebuyers, and retire population is seeking. I believe AB 125 identifies a straightforward process to allow consumers to get immediate redress and when construction defects are identified. I urge you to support AB 125 and the much-needed reforms of Chapter 40. Its enactment will encourage timely identification and repair of claims of defects and discourage unnecessary and expensive litigation and abuse. Thank you for allowing me to testify on this matter.
Thank you very much, Senator. Assemblywoman Dooling, good morning. How are you?
Good morning. Thank you very much for allowing me to share my own personal story regarding construction defect this morning. 20 years ago, my husband and I bought a home in Boulder City. The builder was Falcon Development, and the development was named Key Largo. It was approximately 64 homes located on the side of the hill overlooking Lake Mead. My husband, Richard Dooling, was on the board of the HOA. After living in the home approximately 5 years, the HOA was contacted by a law firm named Maynard and Harris to do a presentation at the Homeowners Association meeting on the supposed many construction defects in our community. The presenters were Richard Harris and Nancy Kwan. Their presentation showed many slide photos of cracks in cements, areas where patios were not maybe attached to the homes properly, other issues with doors, these exhibits appeared to be issues that possibly homeowners had done after they had installed extra patios. Those were the exhibits, it appeared, that were being shown. The HOA was asked to join a class action lawsuit. Due to the unprofessional presentation and lack of validation with respect to the photos, no homeowners' names or addresses where we could validate these different exhibits were given to us. We did not participate. We chose and voted not to participate in this class action lawsuit. I would also like to mention that Falcon Development had come back into the community and repaired many different complaints homeowners did have with respect to certain grading faults, which was very expensive to repair. After moving to another development in Seven Hills area in Henderson, we were able to purchase a model home which required a signed contract that we were purchasing the home as is. After a period of approximately 5 years, the French doors all over the home were leaking every time there was a rainstorm, and I simply called up the builder, which was Pardee Homes, to inquire as to someone who could come out and repair the French doors. I would like you to know that Pardee came out and replaced 6 sets of French doors, as well as all the flooring around in the rooms where the doors were located. This is a builder who does stand behind their work. I am supporting AB 125, and I urge all of you to support it also. Thank you.
Thank you, Assemblywoman. Are there any questions for the 3 people on the panel at the moment? One from Senator Ford. Oh, no, not yet? Okay. Well, thank you then. I'd like to have 3 more people come up. I believe, Mr. Hicks, you're going to actually go through the bill. Very good. We'll start with you, and we can fill up the tables. That'd be great. I'm sorry.
Mr. Chair, if I could excuse myself, I need to get over to Ways and Means.
Back to Ways and Means. I understand. Thank you, Mr. Majority Leader. Mr. Hicks, good morning. We'll start with you.
Good morning, Mr. Chairman, members of the committee, and Mr. Senate Chairman as well. Josh Hicks, for the record, on behalf of the Nevada Home Builders Association. We're going to walk through the bill. This is the point where you get the table of attorneys to help walk through this. We know this is a busy hearing, so we're going to try to be quick and concise. I just want to introduce the people up here with me. Mr. Craig Marquis, who's with the Nevada Subcontractors Association. He and I will primarily do the walkthrough. Also up here is Paul Jorgensen with McDonald Carano, and Dave Jennings with D.R. Horton to help answer some questions if there are any. Just as a brief preamble before going into this, I'm here on behalf today on the Nevada Home Builders Association. It's 23,000 employees and members, and it's 16,000 licensed contractors. This is a bill we've been working on for quite some time in various iterations. It's something we think is a very reasonable bill. We've gone through the dialogue of everything from should Chapter 40 be repealed to should Chapter 40 be salvaged. And as you heard from some of the prior speakers, there's a real problem out there in terms of the litigation incentives in this case. After doing a lot of thinking about this, what we came up with was that we wanted to salvage the intent of Chapter 40, which was originally intended to provide a notice and opportunity to repair to builders. That's what builders want to do. They want to get homes fixed. That's what homeowners want. They want to get things fixed. And they want to avoid litigation. So everything in this bill is designed to accomplish those goals, and that's what we were trying to do through this process. So I just make that as some preliminary comments. Mr. Marquis is going to walk through about half the concepts in the bill, and then I'll walk through the other half.
Go ahead.
Chairman Hanson, Chairman Brower, good morning. Craig Marquis as well to the committee members. I'm General Counsel for the Nevada Subcontractors Association. I'm General Counsel for approximately 35 subcontractors here in the state of Nevada. Since 2007, I've had the pleasure of coming up to the legislature during each of the sessions to discuss constructional defect issues as well as reform. Over those years, the big impetus behind getting some meaningful discussions with respect to reform is centered on several key topics, each of which has been addressed in this particular bill, AB 125. The big problem that has divided the construction industry over the years has been the issue of indemnification, and that was at the end of last session, the first topic that the industry itself was tasked with from leadership. We were directed essentially to meet, get together, and resolve this issue collectively among ourselves, and that is exactly what we did as our first order of business. For approximately 18 months, representatives from the builder and developer contingent as well as the subcontractor contingent met at least monthly to walk through all of the logistics. The language that resulted in the resolution among the construction industry was originally pre-filed as AB1. That language has been incorporated in its totality into Section 2 of the bill. The particular language regarding indemnity addresses primarily the issue of who is going to be responsible or ultimately paying for the particular defects that are at issue. But this particular section is interrelated with several other key sections of the bill, which I'll be addressing in my comments. Section 6, the definition of a defect, Section 8, addressing the issue of specificity, as well as Section 11, detailing the inspection process. What I would like to do, because these concepts are very difficult to grasp, is give you a 40,000-foot view of essentially what the indemnification provisions provide, which is the first half of Section 2, and then essentially address the issue of RAP, or owner-controlled insurance programs, which is the second portion of Section 2 of the bill. Essentially, in every subcontract agreement that is entered into, the controlling party, the builder-developer, hires subcontractors to perform particular scopes of work. Within those contracts, there are indemnification provisions. Historically, there have been different types of indemnification which have been used in the marketplace. You may be familiar with the acronyms Type 1, Type 2, or Type 3. Type 1 is essentially a requirement that a subcontractor holds a controlling party or higher tiered party indemnified and held harmless for anything that happens on the project, even the controlling party's own fault or responsibility. Type 2 is a hybrid of that, which essentially allows for some apportionment of liability on the part of the controlling party, but only for active negligence, where they have actually had some culpability with respect to the issue at hand. And within the industry, what unfortunately transpired over the years is that there were many occasions where subcontractors, because of constructional defect issues, who were no longer able to continue their operations. There was a lot of insurance policies that were burned through limits, so there was a big hole that was created for being able to collect enough money to satisfy the various allegations and defects that had been raised in suits. So as a result of that, one of the issues that surfaced was an apportionment, or I should say a reapportionment, by the builder-developer to other subcontractors whose work was not implicated, but yet were asked to pay a larger piece of the pie in order to extricate themselves for lawsuits. So the market essentially developed into a Type 3 indemnity environment, which is essentially saying a subcontractor is only responsible to the extent their work causes a particular problem, and the defect at issue arises out of, relates to, or is connected with that subcontractor's scope of work. In other words, the subcontractor is only going to be held responsible for that which they truly do and cause on the project, okay? So Section 1A of Section 2 of the bill essentially addresses the issue that in Nevada now going forward, Type 1 and Type 2 indemnity provisions are going to be declared void and unenforceable as against the public policy of the state. Section B is going to enact that Type 3 indemnity is now the law and is appropriate going forward to hold subcontractors responsible for their respective scopes of work. So to the extent that there is a claim, action, or causes of action that arise or relate out of that particular scope of work, or an omission on the part of a subcontractor, that subcontractor is fully responsible for those issues. Subsection C, however, carves out a limitation. In a construction project, there are times where there are overlapping of trades, and sometimes one particular trade isn't finished with a particular scope of work. Maybe some work gets covered. And the issue here is that in the event that a particular subcontractor's work has been altered or modified, either by another trade or by the controlling party, that that particular portion of the work that's been altered or modified is not going to be the responsibility of the initial installing subcontractor that did the work. In other words, if I've done my work, and even after I'm done, someone comes along and modifies it or alters it, you cannot come back to me as the subcontractor to say, you defectively installed it, you're responsible. Under a Type 3 indemnity, that would be a carve-out, and that particular subcontractor would not be responsible. The party that did alter it, modify it, would be the one who would be held responsible for that particular limited context. Section 1D of Section 2 of the bill essentially designates the triggering point of when a subcontractor is essentially on the hook or responsible for the indemnification and hold harmless provisions. You're generally familiar with Chapter 40 notices under NRS 645, which we'll get into in a few moments when we talk about the notice provisions and specificity. But essentially, the process has been triggered where a claimant, homeowner through counsel typically, sends the builder a letter to say, I have these defects in my home. Under NRS 646, that's builder is required within 30 days to send a copy of that notice to each of the subcontractors whose work might be implicated. And in the context of this provision, Section 1D, in that Chapter 40 notice, presuming it's a compliant Chapter 40 notice that gives the specificity that is required, from which it can be reasonably determined that the subcontractor's work is in fact implicated, that then becomes the trigger for the subcontractor under the indemnity provision to defend and hold harmless the controlling party, the developer, the builder. Now, in the context of that, that's just the triggering point. The additional provisions which follow on subsection E, also addressing in a few moments with respect to the RAP policies, is what's the implication of that. In Section E, if there is a commercial general liability policy of insurance that's in place, and subcontractors doing work on construction projects are either insured under two formats or two types of insurance programs: their own commercial general liability policies, or they participate in an owner-controlled insurance program, which is also called a RAP insurance program. Under the CGL policy, the subcontractors essentially, if there's a claim, make a claim on their own particular insurance policy, and that policy typically assigns defense counsel to represent the subcontractor. In the context of a RAP, which is the second half of this section, essentially in the event of a claim, there is a broker or responsible party. It's responsible essentially for all of the claims that are brought, whether against the builder or any of the subcontractors doing work on the project. So this particular section provides that in the event that there is a commercial general liability policy in place, that the builder developer is not going to initiate the process against the subcontractor, which typically delays this entire defect reform issue of fighting and pointing fingers over who's responsible, who's paying, and what are the circumstances. This particular provision, E1, confirms that the builder community is going to wait to pursue subcontractors. We're going to pursue the issue of insurance coverage, but not let that be the stumbling block to get in the way of getting timely repairs, inspections to address the homeowner's problems as quickly as can possibly be done. The rest of these provisions in Section E essentially address that issue of the timing and circumstances of when the collection of any unsatisfied or unclaimed portion of attorney's fees and costs that the builder incurs as a result of their own indemnity rights. That is going to be the trigger at the end of the proceeding. And as a result of the language in E3, the builders are not going to be precluded from participating in a Chapter 40 proceeding or filing a third-party complaint. The RAP insurance provisions, which are in Section 2, essentially deal with the owner-controlled participation in an insurance program. That is where all of the contractors that are doing work on a particular project pay a portion of the cost of the policy. That's called their contribution percentage. And there are procedures in place where the builders are going to have certain disclosure obligations to their subcontractors, how much coverage there is, how many particular projects the policy covers. In the event that these are multi-year policies that exist, each year when they do work agreements or add additional homes by separate agreements, how much coverage will be left. and those disclosures are set forth in detail in Section 2. Okay?
Mr. Marquis, we got to keep it 50,000 foot.
Yeah.
Getting way into the weeds too much, so
That-
wind it up.
I appreciate that, and this particular section is important because this section gives you the context now to understand the other provisions and why these particular changes are so important. Because of that fighting that took place between the finger pointing of who's responsible and for what, now we fixed that problem so we can get to the heart of the issues as to what really we're fighting over, okay? What are the legitimate issues and what aren't? So let me address now Section 6 of the bill, which is the definition of constructional defect. Under the current law, the definition of a defect under NRS 4615 is very broadly defined. Essentially, a defect is a defect. And unfortunately, in our industry, that doesn't provide enough clarification. That includes betterments, where most subcontractors and builders, although the code is a certain requirement, a minimum requirement, most subcontractors and builders are actually installing way above the code requirements. Under the current law, those are considered defects for which Chapter 40 claims could be brought, even though it's an improved installation methodology. So the definition here that has been set forth in Section 6 of the bill is essentially to provide clarity. It is going to define a defect as one which presents an unreasonable risk of injury to person or property, or it is one which is not completed in a good and workmanlike manner and proximately causes physical damage to the home. The requirement here of physical damage to the home and done in a good and workmanlike manner is to ensure that if there has to be some manifestation of property damage, there has to be something physically wrong in order for that particular component to be a defect. But rest assured, this is not eliminating any particular issues that might be a life or health or safety issue for the homeowner. There is coverage in that with respect to the unreasonable risk of injury to person or property. So, for example, if it's a violation of a fire code issue, if it's a sewer issue, if it's a gas line issue, anything that would present a risk or concern to the homeowner or the safety or well-being of those occupants is covered under the defined statutory provision as proposed in Section 6. Section 8 of the bill deals with this specificity in the Chapter 40 notice procedures. I alluded to several provisions earlier with respect to the process of Chapter 40 notices and how they're implemented. Unfortunately, in practice, and the district courts here have upheld the very vagueness of the Chapter 40 notice. You may have heard the expression shotgun notices. Unfortunately, our industry has permitted notices to go of noticing the builder of the particular claim defects. I have a problem in my home with my concrete stucco framing drywall. Under Chapter 40, NRS 645, the statute is very clear as to what it required. Unfortunately, it had never been enforced. The statute requires specificity. You're supposed to define what's wrong, where it's wrong, nature and extent, and causes to the extent they're known. So those shotgun notices about problems with concrete stucco roofing framing did not do that. As a result, the industry was required to go out under Chapter 40, and all of the builders and all of the subcontractors with their customer service wings, instead of going out and addressing problems, were forced to go out and do inspections to do the needle in the haystack approach, to basically re-inspect all of their work without being told exactly what's wrong, where it's wrong, so that they could do a meaningful investigation. The changes that have been incorporated into this particular statute ensure that that specificity is a requirement and it is to be provided. The exact location of defects, that will solve tremendous problems with making these claims, tendering them on, doing the investigation as necessary to get the legitimate problems of the homeowners fixed as absolutely quickly as possible. The other provision in here is a requirement that the homeowner or a homeowners association officer or executive board member sign a verification statement essentially validating the issues that are being claimed as a particular defect on a home-by-home basis. The importance of that is that traditionally there's been allowed a representative sampling. So there may be in a particular scenario 100 homes that are being represented in a particular matter, and only 10 or 20 homes might be inspected, maybe a couple of each particular plan type or model, and they extrapolate to say, well, the alleged defects that we're claiming in these 4 or 5 homes are going to be prevalent in each of the other homes throughout this development. That's not going to be allowed anymore. Each home is going to have a specific list of defects so that each home can be inspected and the homeowner's issues addressed rather than done in a representative format. The issue you may hear in opposition at some point here this morning is a concern with the verification process, and that somehow that's not fair or that's not appropriate. Want to alert the committee that there are several statutory provisions in Nevada that do require verified complaints or verified papers to be submitted in the case of making a claim. Adverse possession under NRS 40090, unlawful detainer actions under NRS 40370, wrongful lockout proceedings under NRS 118C210, unlawful removal proceedings under NRS.
Mr. Marquis, can you wrap that up?
Yeah,
We're getting
be happy
way
to.
off in the weeds. We're up against a time.
No worries,
element.
Chairman, I understand. So the net effect is there are multiple provisions that require verification of statements, and it's not inappropriate to require a homeowner making a claim on their particular homes to do so as well. The last section, which I'll address in the first part of the commentary, deals with inspections under Section 11. The key there is that when the inspections are done, a homeowner who is knowledgeable, an expert who has written an expert report, or the expert's designee should be at the home to walk the subcontractors and the builders through the inspection process to specifically point out the defect allegation and its specific location to ensure, again, that these needle-in-the-haystack inspections are not being done, but specific inspections to address the particular issues. And those are my preliminary comments. I'll turn it over to Mr. Hicks for his sections.
Thank you. Mr. Hicks, please proceed.
Thank you, Mr. Chairman. I'm going to walk you through the rest of the concepts in this. I'll try to do this as concisely as I can. One of the other concepts in this bill has to do with the ability of a homeowners association to bring these Chapter 40 cases. You heard in some of the preamble some of the problems that has come up with that. Very few people getting involved with these on their own. They're solicited in typically through their HOA. If you look into Nellis, we've put some examples of those solicitation letters in for you to consider as well. Not to mention that the enticements there and were at the root of the HOA scandal, which we put some media articles in about that as well. So to address that problem, what we did was put in a section in Section 20 and in Section 5, which simply says that an HOA does not have standing to bring these kind of cases for anything except a common element. So it's a very simple concept that's in there. There is a whole host of other lineouts throughout the bill in Sections 9, 10, 12, 13, and 22. And they all tie off to that. And the deletion of 46452 in this bill is the same thing. Those all are processes for an HOA to bring these kind of cases. And we are proposing eliminating that. Nothing would stop homeowners from banding together and forming a class if that was appropriate to pursue these kind of cases, but we have not thought an HOA is the appropriate vehicle to do this. So that's the HOA piece.
Mr. Hicks? Excuse me, Mr. Chairman. Just a quick question on that. I suspect that part of the rationale behind that last provision you mentioned, that is precluding HOAs from bringing these cases, relates to the corruption scandal and the criminal investigation that the Department of Justice is pursuing in Clark County currently. And without getting into the details on that, I think you and I both know them well. Is that part of the rationale there?
Yes, Senator Brower, that is exactly the rationale. This system was taken advantage of by some unscrupulous people. The enticements were there under Chapter 40 to steer these construction contracts and these kind of cases, and that was the heart of that case. That wasn't always in the media, but those of us who followed that know that this was the heart of the case, and we are trying to stop that from happening again with this section.
And I appreciate you putting that in there because, as you point out, it was actually more than a few bad actors. I think there have been more than 24 guilty pleas, 4 suicides, and just a real mess. But I think to say that was an isolated incident and that it is not likely to be repeated in light of the prosecutions, I think would be, just wouldn't be accurate. And so I think this is important, and thank you for inserting that. Thank you, Mr. Chairman.
I'll indulge you, a former federal prosecutor here. Mr. Hicks, go ahead and let's wind up getting through the bill, and then we're going to get to questions. Well, actually, I want Mr. Jorgensen to have his opportunity, and you, sir, as well. So then we'll get to questions. So let's hold off on the questions to get through this. We are up against the clock, so.
Section 15 was what I'd like to direct you to next, and Section 3, they kind of work in conjunction. This is the attorney's fees. Those of you who've been on judiciary in prior sessions have heard about this. The uniqueness of these fees being listed as damages in these kind of cases, that has resulted in what the courts have called an entitlement to these fees, and that's where we've seen a lot of these problems in these cases start getting driven by fees instead of by resolution. That's been a real problem. So our proposal has been to restore the American rule of law. That's the typical rule that exists in other civil cases where the parties bear their own fees and costs, absent some extraordinary outside issue on that. And also another portion of that is on the costs. We actually put in language about costs should only be awardable for defects that are actually proven. We don't think that the contractor should have to be paying for costs, destructive testing, things like that, that actually don't end up resulting in any kind of cost that's ever proven at trial. Section 3 of the bill, which is to be read in conjunction with that, has to do with offers of judgment. Those are typically settlement tools in litigation, but they can't, in any civil case, you actually have to have a lawsuit. Chapter 40 is a pre-litigation process. So you cannot make these kind of offers of judgment right now until you actually get into litigation. We wanted to put that in there because it gives the homeowner a tool to make settlement offers right at the start. If that's rejected by a home builder, the home builder is at serious risk of having to pay all fees and costs in the case. So there's protection there to try to deal with home builders who may have really caused a real problem and are really resistant to work with somebody. The warranty section I'd like to move to, section 14 of the bill. This is a requirement that if there are available home warranties on the home, that those are exhausted prior to going to litigation. The polling we've seen has shown that most people are not always aware that they even have a warranty. They don't even think about the warranty. They go right into litigation. And again, what we're trying to do is exhaust all options before going to litigation. That should be the end result. So if there's a warranty on there, we'd like to see that pursued. That's an easy way for homeowners to pursue something. They don't need attorneys. They don't need to incur a lot of expenses to do that. There's a clause in there as well that will toll the Chapter 40 process while the warranty claim is being pursued, so that there's no risk of losing your ultimate right to proceed to court if that's what you need to do. Finally, there's a tolling provision in Section 16. Chapter 40, when it was initially enacted, was supposed to be a relatively quick process. I believe it was about 180 days you were supposed to get from start to finish on this thing, and if you couldn't get it resolved in the Chapter 40 piece, then you'd go into court. So time has told that a lot of these cases go on much longer than that. So we put in a clause that would once a year went by, the tolling of the statute of repose would stop. The idea is to encourage the prompt resolution of these cases, get them going, and not let them drag on and on for years in the mediation context. Other than that, I'm just going to cover this. Other than that, the other portion of the bill is the statute of repose, which is in Section 17, and then it has some deletions in 22 and 23. Right now, there are differing periods of repose, which is how long you can actually bring a defect, and that varies from 6 to 10 years. So that actually, our proposal is to put that to 6 to make it consistent. That's what a breach of contract claim is in Nevada. I do want to make sure the committee is aware that we also have a section in here in Section 22, I believe it is, that makes these effective on passage and approval. So we are trying to move quickly on some of these things, and the statute of repose is something that would be covered under that as well. So that is my overview. I think Mr. Jorgensen may want to add something on.
Briefly, Mr. Jorgensen.
Yes, Mr. Chairman, Paul Jorgensen, McDonald Corona Wilson, on behalf of the Nevada chapter of the Associated General Contractors. Very briefly, because of the time constraints, Chapter 40 was passed with good intentions, but it hasn't worked. It's been subject to problems. It's been subject to abuses. It hasn't helped homeowners. It hasn't properly protected the builders. We have taken a step back and looked at how do we fix it? How do we get back to its original intentions? And that's what we believe AB 125 does. I want to yield any other time I have to anybody else who wants to testify, but I'm available for any questions, of course.
Very good, thank you. One more, and then we're going to go to questions.
Good morning, Mr. Chairman, members of the committee. I'm Dave Jennings. I'm in-house counsel for D.R. Horton. I've been there for the past 9 years, and my primary task has been to oversee kind of the construction defect litigation that involves D.R. Horton. I just echo Mr. Jorgensen's comments. I think the ideal of NRS 40 is good. I think the idea that builders can come in and subcontractors come in and fix whatever mistakes they may have made is a good ideal, but it is clearly broken, and I know that from daily practice in that. So, and then I'm here to help answer questions if there are any. Thank you.
Thank you, Mr. Jennings. Before we go to questions, just a reminder, when you have somebody ask you a question, you don't have to go through the chair in this hearing. You can go directly to whoever's asking the question. Mr. Anderson was up first, and then Ms. Diaz.
Thank you, Mr. Chairman, and good morning to all of you. I wanted to direct your attention to Section 6, which is on the bottom of page 10, at top of page 11. Of course, that's the definition of a constructional defect. Now, you're taking out, striking out the code violation. Now, if a house isn't built to code, it seems like someone has to be responsible to bring that up to code, and it's probably going to be the homeowner that would have to bring it up to code. Now, if they don't and they try to sell, it seems like this could hurt the value of their home, leading to an economic loss when they sell. Do you think it's fair for the homeowner to have to deal with this when they weren't the reason it isn't up to code?
Thank you, Assemblyman Anderson. I'll go ahead and take a quick crack at that. As an initial matter, I want to make it clear that striking that language about violation of code does not mean that violations of code are not actionable. There's a clause in there about anything with an unreasonable risk of injury to persons or property. So if you've got serious code violations, you've got an actionable Chapter 40 item. What we're trying to get rid of were some of the cosmetic, non-big ticket kind of items out of this thing. And to deal with those, there are other options that homeowners have. They have options by contacting their builder under their existing warranties. They have contractors board options. They can file complaints against contractors who don't perform the appropriate kind of work. But that's what we were trying to get out, was the things that belong in litigation should be much more serious, and that's what we're trying to get at with this thing. I'll also point out that the existing law as it is for a violation of a code would actually make something that is done in excess of a code, even better than a code, an actual construction defect. And I know some of the people up here have actually seen that in cases. So that's been a problem we're trying to fix as well.
Just a reminder before you answer to be sure and state your name. That was Mr. Hicks for the record. Ms. Diaz.
Thank you, Mr. Chair. My question relates to the statute of limitations. As I was reading the bill, I was a little confused. So it's what I gather, and this is by no means my area of expertise, but so most homeowners will just have 1 year to toll for the construction defect that might be in their home?
Assemblyman Diaz, Craig Marquis. With respect to the tolling provision on the Chapter 40, typically what's happened in Chapter 40 proceedings is, although this provisions essentially were for a 180-day period, these have gone on for years. And the impact of this tolling provision is to provide that we are going to get through Chapter 40 under the proposed language within a year or less. So during that year or less that you're participating in the Chapter 40 proceeding, all statutes are tolled. So the whole point of Chapter 40 was to be a pre-litigation process by which people could have legitimate issues addressed, work through potential warranties and the right to repair, and in the event that that happens, it's going to happen within a year. If for some reason the matters cannot get amicably resolved, the homeowner has absolutely the same recourses they have previously and existing currently, which is they have the right to proceed with a lawsuit. It's during that interval period of time that all statutes are tolled during the participation of the Chapter 40 process.
Well, in the end, it seems to me that just limiting it to a year, it's protecting more of the contractors. Then there might be genuine lawsuits, and it might take more than a year for a homeowner to discover a defect. So I just, I don't want to then make legitimate cases, genuine lawsuits, hamstring because we have this 1 year limitation.
Assemblyman Diaz, my name is Paul Georgeson. I just want to make a clarification. There's a difference between the statutes of repose and the tolling you're talking about. The statute of repose in this bill is 6 years from the date the house was built. You have a claim, ability to bring a lawsuit at any time within 6 years after the house was built. The 1 year tolling only applies to the Chapter 40 process after it's been initiated. So I just want to make it clear, you don't have to file your lawsuit within 1 year, you have to file it within 6 years.
Senator Ford.
Thank you, Mr. Chair, and thank you, gentlemen at the table. Let me say at the outset, I actually appreciate getting into the weeds on this. This is an important issue. The room is filled. The room is filled in Southern Nevada. And the public has the right to understand the changes you're trying to make that are going to affect their homeowners' rights. And so I appreciate the weeds, Mr. Marquis. And let me ask you a quick question. My questions relate to Section 8, as well as the statute of limitations provision that Assemblywoman Diaz just referenced. You gave examples about how the law, well, actually, let me first acknowledge the problem. We've acknowledged, and this acknowledgement is not new. I've acknowledged this problem last session, attempting to forge an opportunity to fix construction defect issues. And Mr. Hicks, you know that I've been corresponding with you for almost a year now, working with leading builders of America and local home builders, trying to forge an effort here to fix this problem. Mr. Marquis' presentation on subsection 2 is exactly how it should have been done. 18 months of working together, a compromised piece of work that I have no issue with. The rest of this is problematic. And one of the issues that I'm most concerned about is the verification component you're talking about. You've highlighted examples throughout statutes already where that is required, but that is not the same thing. What we're looking at here are essentially expert testimony that we in our legal jobs hire experts to talk about defects. And you're trying to require in this bill a layperson who doesn't know anything about defects to testify under penalty of perjury that they have a defect. I'd like you to address that, and then I'd like for you to also address the issue of the statute of limitations. You want to lower it from 10 to 6 because that's what comparable breach of contracts claims are. But this isn't a breach of contract claim. This is a 30-year mortgage, typically. This is a person's 75% of their wealth at the end of their work. And I think that we have a problem when you want to lower this to 6 years from 10. So if you could speak to those issues, I would appreciate it.
Certainly. Craig Marquis, Senator Ford. With respect to your verification question under subsection 8 under the Chapter 40 notice, requiring a homeowner to verify the defects that have been alleged in their home is no different than a plaintiff making allegations in a complaint. Ultimately, it's the complainant that's making the allegations. Now, they can rely upon an expert to be the basis of that information that they have as their representation as to their understanding of what the defects are. And there's nothing wrong with that. They're relying upon that particular person's input, whether it's an expert or some other person. The issue here of the verification is homeowners cannot be required to disclose attorney-client privileged communications. That would not be proper. It would be an improper way in which to do that. So by requiring the homeowner to do the verification, that's putting the burden back on the person that's making the claim. It's no different than when a homeowner ultimately goes to sell their home. There's a seller's real property disclosure statement that's required to be filled out to apprise these potential purchasers as to what, if any, defects they're aware of in the home, whether or not they've been repaired, and if not, they indicate that. That's on the homeowner. That burden is on the homeowner's responsibility under Nevada law to detail those. That is no different than a verification statement. If they're aware of it, they should be disclosing it. And that's the burden. It forces the homeowner to make sure that when they're going forward with this process that they are doing so knowingly and intentionally, not to be misled in the process along the way, to have a whole host of claims or allegations made that aren't legitimate. It puts the burden to make sure that only legitimate ones go forward and are advanced. And requiring a homeowner to sign a statement under penalty of perjury is no different than a potential Rule 11 sanction under Nevada Rules of Civil Procedure if they should file a complaint, or in the event of a claim of fraud or misrepresentation, should a subsequent home buyer come in later and say that I was misled, there was a defect in the home and you didn't disclose it to me, you took money for it and didn't repair it. So that particular provision I don't see as an impetus or a problem requiring a homeowner up front in this process. Again, the whole purpose of this in this modification is to re-energize that communication process between the homeowner and the home builder and the construction industry and subcontractors to get their legitimate problems fixed. Not make it go on for multiple years as Chapter 40 has transpired. Our focus now is let's make this a year or less process. Let's get these homeowners' legitimate concerns addressed. Going to your second issue, Senator Ford, with respect to the statute of limitations. States throughout the United States have multiple periods of statutes of repose. Those range from 4 to 10 years. Our neighboring states have adopted statutes ranging from 6 to 10 years. By way of example, Colorado is 6, California is 10, Arizona
Mr. Marquis, we don't have time to go into every detail in every state. Let's wind it up.
Sure. The net effect is that when you look at the impetus behind this change of reducing it from a 10-year to 6-year period, the reality is most constructional defects that are going to be known to the homeowner are going to surface within that first year or so of them actually owning their home. most every builder has a one-year customer service walkthrough program in place where at the end of that year, the home builders go in with the homeowner, do a walk room by room, identify on a punch list all of the particular issues that the homeowner claims is wrong. The home builder takes care of that with its subcontractor base through its warranty program. So with respect to those legitimate defects or issues that are, whether they're cosmetic and addressed, those are going to be known within the first year or so of the home being owned by that homeowner and those problems addressed. Most constructional defect claims, if you look at the history of the different lawsuits, most of the lawsuits are being filed within a 3 to 5 year period after a substantial completion of the home and the homeowners come into this mix. So by giving a 6-year statute of limitations, you're actually giving them more than enough time to identify those particular problems should they arise, and you give them an opportunity to go through Chapter 40 so that you have a 6-year statute of limitations. If for some reason that is a claim that surfaces within that 5th year up until that 6th year, somebody triggers a Chapter 40 notice, all statutes of limitation are told for the period of the year, so the net effect is that they're going to have plenty of time to walk through those issues and have them addressed. What is carved out from this particular statute is in the event of a particular product defect claim, and in the event of a product defect claim where there's some serious problem that arises that's a latent, maybe a potential plumbing failure behind a wall, then there'd be other ramifications that can be pursued against the product manufacturer for those particular claims.
All right, thank you, Mr. Markey. Well, Senator Brower, then Mr. Orenshaw, then Mr. Araujo.
Thank you very much, Mr. Chairman. Just a quick question to clarify, hopefully, and I think we all appreciate where Senator Ford was coming from on the verification issue, but as I read the proposed language, we're not expecting a homeowner to verify the detailed nature of a defect such as an expert might and would do. We're simply requiring that a homeowner verify, acknowledge that, yes, I do have this problem in my home, which, as I understand it, believe it or not, has not always been the case in this litigation. Can I just get a quick clarification on that? Mr. Markey, if I'm wrong, please tell me I'm wrong.
Senator Brower, you're absolutely correct. Craig Markey.
Thank you.
Thank you. Mr. Orenshaw?
Thank you very much, Mr. Chairman. I think we all agree that whatever happens with this bill, whether it passes in this form or is amended, we all want to see defects repaired as quickly as possible, as painlessly as possible. My question to the proponents of this bill is, have you reached out to the insurers for those subs? Are there representations, are there commitments that if this bill passes as is, the premiums for the subcontractors will go down and that there will be more of an effort, of a focus on trying to get the repair done as opposed to fighting and to dragging it out? I just wonder, have your conversations as you've worked on this legislation included the insurers, and do you have any representations or commitments that those premiums will go down and that there will be more of an effort to repair?
Thank you, Assemblyman Orenshaw. Josh Hicks for the record. I'm just going to quickly answer, and I'd like Mr. Markey to answer too. One of the things we have seen out there is that the rising cost of these insurance premiums, one of the real problems it's caused is it has squeezed out a lot of the small builders out of the market. It's about, I think it's 340% less market share in Nevada than anywhere else in the country. And that is a direct result of insurance premiums being very high because of this. So your question is a very pertinent one, and it's a very important one. I can tell you from the few conversations I've had with some insurers, they have told me that they think that this will make things much easier for them to insure. But I don't have anything specific to give you other than just my comments with them. And Mr. Markey may be able to add on to that as well.
Assemblyman Orenshaw, Craig Markey. During the course of this process of the meetings with the builders' representatives and the subcontractor representatives to address indemnity, one of the other pieces of the puzzle was insurance. So we did have input from the insurance industry with respect to these modifications that were being proposed. One of the positive signs that came from the insurance industry was that because of the reforms that were going to be proposed and advocated, is that would actually improve competition within the marketplace. We've had so many insurance carriers for subcontractors over the years actually leave the market that there hasn't been very good competition, and subcontractors have been required to pay astronomical deductibles or policy premiums for coverage, and it's not the best of coverage. So by eliminating a lot of these non-issues and making this law a little bit more clear and workable in order to make sure that the homeowner's problems can be addressed on a reduced time frame, you are saving hundreds of millions of dollars, if not into the billions of dollars, as a result of insurance payments that are being made, mostly because of the attorney's fees and costs and prejudgment interest that is accumulated in these lawsuits. So because this will now be reduced down to a year period of time, because there now will be a greater emphasis on the builders and subcontractors actually being afforded their right to repair, this will actually encourage the industry to come back in with more competition, better coverage, and better premiums for all parties involved.
A brief follow-up, Mr. Chairman. So
Very brief.
Very brief. So if I understand you correctly, then you're optimistic, you're hopeful this will lower premiums, but again, there's been no concrete representation or commitment from the industry that the passage of this legislation will lower premiums for the subs or lead to repairs quicker.
Assemblyman Ornshall, Craig Markey, again, most insurance companies can't give you definitive answers because they don't rate through their underwriting policy, programs. They can't give you pricing of policies until they actually rate a particular subcontractor or builder and assess the risk for a particular policy year. Their comments, however, have been forward-thinking, and they've given us their indication that, yes, it will improve, and it will lead to more competition, which directly will lead to better pricing in the market.
Thank you, Mr. Chairman.
Mr. Araujo?
Thank you, Mr.
Then
Chair.
Mr. Wheeler.
So, gentlemen, if a consumer homeowner were to submit a claim and the defect was too severe and they had to make alternative living arrangements while the defect is being rectified, who would cover those costs for the homeowner?
Assemblyman Arroyo, Josh Hicks, to answer that, that is actually covered as one of the damages in a Chapter 40 case, your loss of use, so it would be covered under that piece of it, of the statute, 4655.
Thank you.
Thank you. Mr. Anderson's going to give you one more, but you already had one I forgot about. So right now, gentlemen, I need 4 more people up at the table. Thank you very much for your testimony. The next group, 4, are going to be limited to 3 minutes in testimony, and then we'll try to go to questions. We're going to have to wrap up in 15 minutes for the proponents, and I'm going to give the equal amount of time to the opponents. Mr. Haw, good morning. We'll start with you.
Good morning, Chairman. Thank you very much. For the record, my name is Jesse Haw. I live at 144 Green Ridge Drive in Reno, and I'm really excited to be here today. We've been working on this since my daughter was 2. She's now in high school. So it's a big day for us. I thank you for your time. I will take less than 3 minutes. Our family's been building in Nevada since the 50s. My grandfather in Henderson, my dad in Winnemucca, and myself in Reno along with my brother. And during that time at the peak, we had over 200 employees. We are down to 4. We saw our insurance premiums go from $37,000 a year to $750,000 a year without a loss. It's got to the point where we have residential lots that we cannot or will not build on because of the problems with Chapter 40. I'm really excited about the language in AB 125, and I can tell you, if that language were to go into effect, if we got everything on there and a homeowner still had a problem, they can still sue their builder. They can first try to get it fixed with the builder. If that doesn't work, we have a contractors board who will go after them. And then there's a residential recovery fund. So at the worst case, the home owner is still right where they are right now. They can still sue their builder. Contractors, simply put, want to fix something when it's incorrect. They want to get something fixed because that benefits their business. They'll have repeat homeowners, repeat buyers. So it's nonsensical to think that they don't want to get this stuff fixed. That's it. I'll just keep it short. I really appreciate your time. I'm so excited to be here right now. We're at the pinnacle of changing something that's going to benefit homeowners, contractors, employees. It's going to put people back to work, and you guys are the ones that are going to do it. And I thank you very much.
Thank you, Mr. Haw. Next.
Thank you, Chairman Hansen, Chairman Brower. Darren Wilson for the record. I represent the Nevada Subcontractors Association. I've been coming to this building for the last 9 sessions, trying to lobby, to work for good reforms, to bring fairness back to our homeowners and fairness back to our subcontracting and contracting industry. I've been an air conditioning contractor in Las Vegas for 28 years. I've seen the boom, I've seen the bust. Daily I look at my mail, it comes in. I constantly have new Chapter 40s or litigation letters that I have to go through daily. I've got 3 people in my office that do nothing but work on Chapter 40. They're not a productive part of any subcontracting business or building business. They work on Chapter 40. The Nevada Subcontractors Association was formed pretty much for Chapter 40. We've been here. We've been united. The last 24 months, we have worked with our building community and our partners in the building industry. We've worked together. We've solved indemnification. I believe we've got good reforms on in this AB125, and I really urge you guys to really reach out and look to see what we can come to terms with and pass this. Insurance premiums, I've got contractors in Arizona, about the same size as my company, pay between $30,000 and $70,000 a year. I pay between $300,000 and $700,000 a year. That is being passed on to our consumer. Any type of cost is passed on to the home builder, which is passed on to the buyer. We really need to look at these reforms to bring insurance rates down, to get our state competitive, to bring people here and create jobs. Our construction industry is important. It's always been important. It's one of the big providers in the state for tax revenues. I urge everyone to really look at this and help us move this forward. Thank you for your time.
Thank you, Mr. Wilson. Senator Kopning, how are you? Long time no see.
Morning to all of you. Chairman Hansen and Chairman Brower and members of the Joint Committee. For the record, my name is Allison Kopning. I'm here as a constituent and citizen to share my personal experiences with construction defect litigation. I think my written testimony goes about 3 minutes, so I'll talk fast. Between 2002 and 2006, I served as a Director of Public Affairs for Pulte Homes and Del Webb. Primary focus of my job was solving critical issues with our tens of thousands of homeowners. The company prided itself on exceptional customer service, and I worked personally with our homeowners on all major problems with the goal of resolution to the homeowner's satisfaction. My experience will emphasize 3 points. Why the current Chapter 40 laws need to be changed to allow for builders and subcontractors to repair before a lawsuit is filed. 2, why community association boards of directors should not be allowed to file lawsuits on behalf of private residences of which they have no jurisdiction. And 3, why it's dangerous policy to make attorneys' fees an entitlement in construction defect litigation. Because of the way that Chapter 40 laws are currently written, Pulte Homes and Del Webb had and still has a huge target on its back. The company built large communities, including Sun City Anthem and Sun City Summerlin, with thousands of rooftops, actually tens of thousands of rooftops. These communities were the target of construction defect attorneys, as the more people one can get signed into a class action, the larger the payout. With attorney fees being paid regardless, litigators had nothing to lose and everything to gain. Needless to say, we've had a handful of class action lawsuits filed against the company. In 2003, a local law firm convinced the board of directors at Sun City McDonald Ranch, a Del Webb community of over 2,500 homes, to enter into a lawsuit over mold that was found in the shower of one of its community centers. Because we had finished building in that community many years earlier, I drafted a letter on behalf of Del Webb's president requesting a meeting to examine the showers to make the repairs if the mold was determined to be a result of our building methods. We had always enjoyed a good relationship with the board, so we believed we could resolve this situation quickly and get the residents back to enjoying their community center. Within days, Del Webb received a letter from the board's attorneys chastising us for attempting to talk with the board members. Several letters went back and forth, with us attempting to work with the attorneys to fix the problem and avoid a costly lawsuit. Each time, the board's attorneys had a myriad of excuses as to why this wasn't possible. After a few letters to the board, we began copying all of the homeowners so they could witness the unwillingness of the board and their attorneys to work with Del Webb to rectify the situation. With each correspondence, we continued to propose a solution to every new concern that the attorneys proposed. Each time, the attorneys had a new excuse as to why this was not possible. Del Webb's solutions included paying for all the repairs, even if it was proven that it was not Del Webb's fault, paying for all the destructive testing, the past and current, and paying for all the attorney fees to date. We also suggested co-authoring a letter to the homeowners to show our unification in wanting to resolve the issue in a timely manner. All of our offers were rejected by the attorneys. Over the next few months, hundreds of homeowners protested to the board over what they viewed was an unjust attack towards Del Webb. They circulated petitions to force the board to drop the lawsuit and let Del Webb repair the shower. all to no avail. Soon we learned that the attorneys were performing destructive testing on single-family homes and duplex homes, which we speculated was the reason they refused to allow us to make the repairs to the shower. Once they had formed a bond with the board members, they could conduct more destructive testing in hopes of filing more class action lawsuits. Their destructive testing did reveal one problem with the firewalls between the duplex units. Rather than approaching Del Webb to make the repairs to the firewalls, the attorneys proceeded to file a class action lawsuit. This time, Del Webb took matters into its own hands. Instead of waiting for the lawsuit to settle many years later, Del Webb began working directly with the duplex owners to make the repairs to their firewalls at no cost to the homeowners. If there had been a fire within the 2 years that it took that lawsuit to make its way through the courts, it could have been devastating for the families, as you can imagine. Almost all of the homeowners dropped out of the lawsuit to allow Del Webb into their homes because all they really wanted was to have their homes repaired. By the time the lawsuit made it to district court, the firewalls had been repaired for all of the duplex owners except for a few that decided to stay in the lawsuit. During the hearings, the judge was perplexed by what had taken place over the past 2 years and verbally reprimanded the attorneys for continuing with the lawsuit and wasting the court's time. Regardless, because of Nevada's laws entitling the attorneys to their fees, they enjoyed a lucrative payout. Copies of 2 letters, one to the homeowners at Sun City McDonald Ranch and a letter to the 2003 legislature, has been provided in your exhibits on Nellis. From my involvement in hearings on this issue over the past years, both as a sitting senator and as a citizen, I have heard the opposition say without entitled legal fees, homeowners would not be able to afford to retain legal counsel. This has always been puzzling to me. If the construction defect laws were like all other laws, an attorney could represent a client on a contingency basis. So why would an attorney turn down a construction defect case that could be paid out on contingency? It's a question I think a construction defect litigator would need to answer. In conclusion, when you think about it, building a home is very much like building a vehicle in that both are comprised of thousands of parts and both can have issues on those parts. When a problem is discovered within a vehicle, the manufacturer issues a recall and the owners bring their vehicles in for repairs. Common sense tells us if we have a problem with our vehicle, we take it back to the dealer. If the dealer refuses to repair the defective part, then we can pursue legal remedies. Can you imagine how problematic it would be if millions of people affected by vehicle recalls bypassed the dealer and went straight into the courts to resolve their problem? It doesn't make a lot of sense, does it? Well, this is exactly what has been happening over the past decade because of the current Chapter 40 laws. I thank you so much for your time today and appreciate your consideration in supporting AB 125. Thank you.
Senator, thank you. By the way, the work of Senator Kopning, Senator Snyder, and Senator Terry Kerr are all rolled up in this bill, as well as the Section 2 is the work of former Speaker Marilyn Kirkpatrick. Paul, you're up next.
Good morning, Mr. Chairman, members of the Joint Committee. Paul Moratkin, Vice President of Government Affairs for Las Vegas Metro Chamber of Commerce. As the state's largest business organization, we believe that it is apparent that there is a justified need to reform state law pertaining to construction defects because of the adverse impact the current state law has on the housing market and to the construction industry, which includes single and multifamily housing. We believe that reform should be focused on the following areas: to restore clarity to the process, encourage prompt resolution of disputes, reduce litigation costs, and provide procedures and processes that are understandable to all interested parties. The current system is a concern for the Metro Chamber of Commerce, and we believe that reform is needed now. Current state laws hindering the housing market and are placing pressure on our state's economic recovery. The Metro Chamber believes there needs to be a balanced and fair approach by providing home builders the opportunity to make repairs and addressing claims filed by homeowners. The current system does not encourage resolution between the home builder and the homeowner. Rather, it creates an environment of adversary between the interested parties. We believe that reforming these statutes will help assist in the economic recovery of our state and assist the construction sector in their recovery, not just in Southern Nevada, but throughout our entire state. This bill is also about supporting economic development efforts and creating good-paying jobs, which will help Nevada's economy grow. We know that construction jobs are important to our economy. That the last recession has taught us that. And that is why the Metro Chamber supports AB 125. Thank you, Mr. Chairman, for your time and allowing me to speak on behalf of the Metro Chamber of Commerce today.
Thank you very much. What we will do at this point, I don't have time to take any more testimony of proponents. However, we will have questions at this point for these 4 panelists. Anybody have any? Senator Ford on the end.
Thank you again, Mr. Chair. I had a follow-up for the last time. I think you didn't hear me. I'm going to take it as an inadvertent oversight in that regard. But I do have questions for this panel. I've heard a lot of horror stories today about attorneys. I get it. As I've said, I've tried to work in this area as well. In my law firm, we defend construction defect litigation, so I understand those concerns. If the question is about frivolous litigation, however, why isn't the solution as simple as removing only the attorney's fees provision and replacing it with the American rule of law? The other options that are placed in here now, again, are onerous and up to debate. And in a short time period we've had to discuss these, they won't be resolved. And we'll be having these issues discussed again over the next few sessions. I can guarantee you that. But maybe you can tell me why simply removing the attorney's fees incentive and replacing it with the American rule of law wouldn't be sufficient for purposes of handling these issues.
For the record, Jesse Haw. I think that is part of it, the attorney's fees or the entitlements to attorney's fees, but there's a lot more that's happened in the last 15 or 20 years, and specificity is a big part of that. We need to know what is wrong with your house. The duration of the time that, for example, the 10 years to 6 years, a realistic duration, we need to know how long we should be responsible for that. So I think there are a lot of other points, Senator Ford, and I do want to thank you, and Senator Ford has been great to work with over the past year with a lot of people in our constituency, and as well as a lot of other Democrats and Republicans. I really don't feel like this is a partisan issue. The majority of my workers are Democrats. Our home buyers are both parties, and I agree this is something we need to work on and continue to work on, Senator.
Thank you. That's a fair point about the specificity, by the way. I can concede that issue as well.
Thank you, Mr. Anderson.
Thank you, Mr. Chairman. Good morning. Before I ask my question, I want to say hello to Senator Copeland and just say it's really phenomenal to see you here again. We miss you. I actually wanted to follow up with Mr. Muradkin. This is something that we've heard from a few witnesses already, talking about how Chapter 40 has been a cause of the housing market declining and the new home market declining. But I mean, wouldn't it be more fair to say that the majority and an approximate cause of the housing market tanking was the real estate crisis and the foreclosure crisis, and of course the associated increase in inventory that really tanked the housing market? Wouldn't that be more fair to say?
Assemblyman Anderson, actually my remarks were directed towards the recovery. If we are able to construct homes and pay those jobs, those housing market would be improved by employing more workers. So and it was a result of the recovery, not the actual cause of the recession.
I'm sorry, I misunderstood you.
Thank you.
We have heard that claim, though, so I just wanted to get that and flesh that out.
Thank you, sir.
Thank you very much. Senator Copeland, I'm sorry, you had one last comment, and we're going to have to move to the
Thank you, Mr. Chairman.
Bill.
Allison Copeland for the record. To Senator Ford's questions about that, again, I would echo also what was said over here as well. But I would also emphasize some of the things the points that I had made about homeowners association boards of directors being able to lead people in it. This community clearly did not want that, and they had no choice. It was what it was because of what the laws had allowed. And I think first and foremost, and the biggest thing that I think you're going to hear from the proponents of this is the builders and the subcontractors just want the right to repair. So even if you take out, the entitled attorney fees, it doesn't still address the fact that we need to have some things in statute that make them the first stop. They've lost a lot as a result, reputation-wise, which was undeserving to them. Subcontractors have gone out of business because they are told by their insurance companies, just settle, you've been named in this, it doesn't have anything to do with you, we're just going to settle, so they settle for whatever amount. Meanwhile, that subcontractor on their record looks like they have settled a class action or a construction defect case, 75 times in their history. It looks like they're a shoddy. So there's just a lot of problems. So thank you for letting me go on about that. I hope that helped to answer.
Thank you very much, Senator. For those of you, thank you, and let's bring the opponents to AB 125 up. For those of you here to testify in favor of 125, you're going to have to submit it in writing. You can do that through Nellis, and you know we know the majority of the folks here where you stand on these issues, and we apologize. We got to be fair to both sides in this, and make sure everybody gets an opportunity to state their case. Speaking of stating their case, how are you, sir?
I'm fine.
If there are you the only opponent to the bill? If there are at least 3 other ones, please come up to the witness table. Are you the only man that's going to testify against the bill today? When you're ready, please go ahead and state your name for the record.
Thank you, Assemblyman Diaz. Good morning, Mr. Chairman and members of the Senate and Assembly. It's a pleasure to be here. My name is Terry Reedy. I'm here on behalf of the Nevada Justice Association. I'm also one of those lawyers who represents homeowners in the state of Nevada. I've had the pleasure over the past 20 to 25 years to represent tens of thousands of Nevada citizens who've had problems with shoddy construction in their homes. And so I bring to you a different perspective than what you've seen here today. And obviously I'm here to testify against AB125. Now, a little bit of history, having been involved directly or indirectly with NRS Chapter 40 since 1995 myself. NRS Chapter 40 was always a bipartisan bill, meant to help homeowners and contractors alike get complaints taken care of without going to court. I think we have a consensus on that developed this morning. And over the years, bipartisan adjustments have been made to the law, but always through a process of dialogue and negotiation between all interested stakeholders, including Nevada homeowners. This morning, you heard from no less than 12 witnesses, including 4 lawyers, who indicated that they've been working on the passage of AB 125 for several months. Yet they've never talked to any of the Nevada stakeholders in their development of this particular piece of litigation. That's unique and represents a change in the way that this body has done business over the last 25 years and perhaps even since statehood. There's always been an opportunity for all interested parties to become involved in the process and to state their piece and to be given a fair opportunity to present their positions. I also want to make note that over the course of the last 20 to 25 years since NRS Chapter 40 has been in place, we saw a massive building boom in Nevada. Contractors were able to build homes despite the fact that the existing NRS Chapter 40 was in place. They were able to employ thousands and tens of thousands of workers successfully throughout that period of time with the existing law that we have in place. They profited immensely from the sale of their homes during the period of time which NRS Chapter 40 was put in place. And over this period of time, again, tens of thousands of homeowners, due to the benefits provided to them under NRS Chapter 40, have been able to successfully resolve their claims with developers and builders. You've heard a lot of outlying situations, but 95 to almost 99% of these claims are resolved amicably, peacefully, civilly, and professionally when you have the right people at the helm who are talking to one another. So there are always outliers. Now, we got AB 125 last week. Last week. Yet here we are in a rather extraordinary joint hearing. The message that sends to Nevada homeowners, respectfully, is not really one of cooperative or open government. It's basically, it seems that the intent of the bill and the manner in which it's presented, with almost 3 days' notice to Nevada homeowners, is to make it harder, more expensive, and time-consuming for homeowners to make claims while concomitantly stripping them of significant legal rights. So, with that background, I'd like to talk to you and give you an overview of what I believe Nevada citizens, ordinary homeowners, and millions of them, would think about each of the provisions that you've heard. Now, I'm not going to get into the weeds. I just want to hit the highlights for you, and then I can leave plenty of time for questions if you have it. Section 2 is rather interesting. The discussion that was had regarding contracts and indemnity rights between contractors and subcontractors. You know, there was always a point in time where I thought that conservatives didn't want to get involved in regulating private contracts between sophisticated commercial parties, but apparently this is an exception to the rule where the government feels it's necessary to get involved in those kinds of private transactions between sophisticated parties like contractors and subcontractors because they believe that there is an apparent economic disadvantage in that relationship. Yet where in this law does the law reflect in any way the economic disadvantage that homeowners face when trying to negotiate a home purchase agreement? For the most part, people sit down in a room, they've got every living good that they have sitting in a U-Haul trailer outside, probably with the gas turned on, and they're presented at closing with a stack of legal documents that they can't possibly read, and they're not given a choice at all whether or not they're going to sign that document, because if they don't sign the document, they have no place to live. You know, so in a sense, if we're going to get involved in a balanced bill that talks about regulating contracts between interested parties in this debate, I would like the board, or I'd like the assembly of people here today to consider the same sort of balance to be provided to homeowners. Aside from that, I don't necessarily disagree, or we don't necessarily disagree with Section 2, but it certainly reflects an interest of certain stakeholders without naturally reflecting the same interest for the same types of economic disadvantages faced by millions of Nevada homeowners. Section 3 regarding offers of judgment is rather interesting. I don't necessarily oppose, we don't necessarily oppose this particular provision in the bill, but my guess is that if you were to go to your friends and your families, regular Nevada homeowners, and tell them that they had this arrow in their quiver called an offer of judgment, and if they made this a claim upon their builder to fix their homes, that they could make an offer of judgment. You know, it took years of law school and almost 25 years of practice to even understand how that device worked. You're placing a scalpel in the hands of children who don't know how to use it. If you ask anybody what an offer of judgment is, a normal homeowner, their eyes are going to spin. They're not going to know what it is, and they're not going to know how to effectively use it. Yet on the other hand, the people who can effectively use it offensively against them would be the contractors with their teams of lawyers who understand the concept of an offer of judgment. So just ask yourself, when you're presenting this bill to a regular homeowner and you say, well, now you have this device called an offer of judgment, what do you think their response is going to be? Will they really understand what it means to navigate the intricacies of Nevada Rule of Civil Procedure 68? And by the way, I only want to point out one thing. This particular section of the bill appears to have been modeled after our Nevada Rule 68, yet it appears to be, there appears to be at least one scrivener's mistake in it in Section 4, subsection C, insofar as the taxable costs are prosecuted from the inception of a claim instead of from the timing of the offer, so you might want to take a look at that. We oppose Section 14 of the law because it requires homeowners to make futile claims on hollow warranty contracts, which only serve to delay their constitutional right to timely access to the courts. For those of you who have read typical homeowner warranty, what you'll notice first is that it's more how do I say this, more form than substance. They're typically providing some coverage for the first year of a home, far less for the second, and almost nothing for the period that's remaining. These are largely used as sales devices to sell homeowners on a warranty that they get, but the terms of which are largely illusory. In my almost 20 years of practice, I can only count on my hands the number of times that any of these warranty claims have been honored in any way, shape, or form. And although I've heard some commentators say that most of the problems in a home should arise within the first year, well, that doesn't meet with my experience as well. If you've got 6 years to give to these people, or 10 years, depending upon where you stand, then you have to expect that there are going to be legitimate claims that arise not only in the first year of one of these warranties, but in years number 2, 3, 4, 5, and 6. And these warranties provide little or no coverage whatsoever during that period of time, yet a homeowner can't even begin to approach the builder, until they've tried to process this warranty claim. Well, that's going to take what, another 3 to 6 months? Because there's nothing in the statute that says that that company has to timely respond. I've oftentimes made claims upon these warranty companies, and at their own discretion, they decide whether they're going to investigate it or respond. So what kind of a delay are we talking about here on what we almost already know to be an almost formless, shapeless, illusory warranty policy? I'm not sure. Plus, no consideration has been given to subsequent owners of homes with respect to this section. Now, if you're an original owner, you might get your homeowner's warranty paperwork from your builder. But what if you sold your home between years 1 and 10 or between years 1 and 6? Most subsequent owners that I know don't have that particular paperwork. So at the very least, there needs to be a mechanism in place within this law that provides that the contractor needs to give the subsequent owner a copy of that warranty policy if they're going to process it. Otherwise, they don't know who to send it to. We oppose Section 6 of the law because it invites contractors to violate minimum building code requirements by striking that as a defined constructional defect. Here, Assemblyman Anderson put his finger directly on it. He asked a pointed question and said, doesn't this mean that people have a reasonable expectation that their homes are built in compliance with the minimum floors that are established by our building codes? One of the things that sets our country and developed countries apart from others is that we actually have minimum building code standards. They provide a floor, a safety net, and reasonable expectations that homeowners can say that whenever they purchase a home, they don't have to think twice about whether it meets these minimum requirements. But it's been stricken from this law. And when asked directly what happened to it, what we heard was, well, maybe there are some building code violations that can be ignored, and maybe some that aren't if they're serious enough. Well, I'm telling you, if you've just purchased a new automobile and you found that there was a large scratch running on your brand new paint job from beginning to end, and you took it into the shop and you asked them to fix that warranty item and they told you, hey, the car still runs, we're not going to fix it. I know how most Nevada citizens would feel about that. There are no insignificant building code violations. When a contractor pulls a permit, they make a promise to the building authorities and a promise to the people of the state of Nevada that they're going to build it to that standard. That's what they do. This law just stripped that provision out. Now, they can say how it's going to be applied, but the way that it's written, it's gone. They may say that there's some back door for it. Maybe, maybe not. But why take that chance when that's the one thing that most homeowners do understand when they purchase a home, is that they're all about what's wrong in their homes. And Senator Ford hit this nail on the head. Lay people, ordinary homeowners, should be able to get on the phone, contact their builder and say, look, I'm not exactly sure why the sewage is coming from my toilet. Can you come and help me figure out what the problem is? But if they thought that they had to verify under oath in advance what the nature of that problem was underground or in their pipes or somewhere else, before they felt comfortable making that claim to the builder, you're not going to have more homes repaired. You're going to have more homeowners turning away from the process because they feel threatened by this punitive measure. There are things that we can probably do to ameliorate that, perhaps taking out the more punitive aspects of it. But as it stands right now, this is going to chill Nevada homeowners' desire to make claims to builders, because you're basically putting them in a position to testify against themselves and be subject to similar or civil or harsh criminal penalties. We oppose Section 15 of the law regarding attorney's fees because it discourages homeowners from seeking legal or expert assistance because they can't afford it. I want to address former Senator Copening, my friends. She said, maybe one of you should ask a trial lawyer a question about this. Well, let me tell you how it works. It's really simple math. If it costs $100 to fix a problem and you have to pay your lawyer $25, you're only going to have $75 to fix your roof. That's the math under this particular equation. As a result of the public policy that's been in place since 1995, we have been able to successfully represent, I don't know, hundreds collectively of thousands of Nevadas, such that they had equal access to justice and put them on parity with some rather well-heeled defendants, large national home builders with teams of lawyers. And that's what you saw today, teams of lawyers. And this is what I see every day, me sitting alone at a table on behalf of Nevada citizens who aren't familiar with the legal process, facing teams of well-paid lawyers. That's what happens. Now, I guess that's a matter of public policy, what you want to do with the attorney's fee provision, but it has provided tremendous amounts of benefits. But I'd like to also comment and I think this was referenced earlier too, is that when this law was originally passed in 1995, there was a trade-off, a bipartisan agreement. Right now, one side of that agreement wants to retrade that deal in exchange for allowing homeowners, as a matter of public policy, to seek legal assistance on what are complicated legal procedures for filing and making claims, which you only want to make even more difficult and hard for them to understand. They gave up substantial legal rights to the contractors, including claims for non-economic damages, punitive damages, and so forth. One of the questions I heard the panel ask was, what happens if this construction defect puts me out of my home? Will I be compensated for that? And the answer is no. No, you won't. Now, if the repair that has to be made will put you out of the house, yes, the law provides for that. But there's a long point between making the claim and getting somebody to agree with it. So there were trade-offs that were made, and today we're seeing in this bill a retrading of a deal without any further benefits being provided to the homeowners. Now, we oppose sections 16 and 17 of the law. This regards the statutes of limitations and repose, because it takes 4 years of existing homeowners' rights away from them without due process, while shortening the time for new homeowners to make claims. Let me make this immediately clear. Homeowners, the tens of thousands that purchased their homes, say between 2005 and 2009, are going to have a 1-year grace period in which to make a claim. And I believe that this was Assemblywoman Diaz who brought this comment to the attention about what the 1 year meant. They didn't answer your question. There is a 1-year grace period that's being given to these people. So first of all, you begin with the taking. The first thing that's being taken is when a person purchases a home, according to existing law, they believe that they have upwards of 10 years for a warranty. Well, you're taking 4 years away, or 40% of what that warranty is away from them. But you're giving them a grace period of 1 year. But with what due process? You and I are familiar with what this law is about to do. But of the 10 to 40,000 people that fit within that time zone, how are they going to figure it out? Are the contractors going to tell them, well, you better get together, your act in the next year, or you're going to lose 3 or 4 years of your warranty? Who's going to tell them that? Who's going to be the Pied Piper that goes out and tells that number of constituents that their legal rights have just been traded? Imagine if you purchased a 10-year warranty on your car, and in the 6th year you learned that the state legislature had just taken 4 years away. And that's what's going to happen for most of these people. They might discover a problem in the 6th, 7th, or 8th year. They might approach a lawyer. They may approach a friend. They may approach you and say, well, I'd like to make a claim. And then you said, sorry, we changed that. And they said, well, I didn't know about that. And I said, I guess you should read every change to the law that's made by the legislature, but it's not realistic. So I have some due process problems with that, but they can be worked with. These are not insurmountable problems. But I want to point out something that's even worse. What's worse is that homeowners are only being given 6 years to make claims, even if the contractor engaged in fraud that the owner couldn't discover. It used to be that we separated normal workmanship issues or defects in construction from fraud, which is a separate species unto itself. There were maybe a 6-year statute for patent defects, 8 years for latent defects, maybe 10 years for what a builder knew or should have known. But there never was a statute of limitations if you could demonstrate reckless disregard for the safety of Nevada homeowners, or willful neglect of building codes in the construction of our home, or just simple outright lies and fraud. Yet they've now collapsed the fraud statute, which was unlimited, into a part of the 6-year statute. That's going to be hard to explain to Nevada homeowners. We oppose Section 5 of the law because it seeks to eliminate the ability of homeowners with common problems to work together, a classic divide and conquer strategy. Why shouldn't homeowners with common problems be able to join forces? They need to do that. These are people of modest means, and that is saying a lot. And if they have common problems in their homes, whether it's a townhome, a condominium community, or a single-family development, if they're all suffering from the same problems, why can't they join forces? Now, I've got to tell you, we've all seen the magic trick where you put your hands in a dark bag and you start pulling out jelly beans. I've got to tell you, if there are 100 jelly beans in that bag and the first 10 that you pull out at random are all red, I got to tell you, there's pretty good odds that the remaining jelly beans in the bag are red. Yet this law seems to be, or at least what I heard from some of the panelists, it may not be this legislature's intent, but what I heard from the panelists is that evidence is insufficient. You have to pull all 100 of those jelly beans out of the bag in order to prove your case. Well, that's an insurmountable burden for people, and that will tremendously increase the burden and cost when there's no scientific or logical reason for it whatsoever. Every day, you and I make decisions about the future based upon pieces of information, the statistics that we heard earlier about what people think, polls that you take. They're not based upon a 100% sampling that you get from your constituents. They're based upon reasonable and reliable and valid samplings. So this part of the law is nothing more than an illusory divide and conquer strategy that I see, meant to separate one homeowner from their neighbor so that they have to incur individually each item of expense, even if the problems are common. This can be corrected as well. I also want to go back to the statutes of limitations and repose for a while just to make another point. Who's to say that a person will discover a latent defect within their home within 6 years? Why 6 years? Right now it's 8 years. Why not 10 years? These determinations are largely arbitrary. But the idea that a person can figure out every problem that's hidden behind their walls or that may manifest in within the first few years is just not reality. That's not what we see. It's just not what we see. We oppose Section 20 of the bill because it prevents homeowners associations from prosecuting claims for property that they share with their members. Think about that. The concern, I understand, policy being driven by some singular abuses by a small number of people that have been corrected through provisions in other laws and prosecutions. Now, there's always a fear of that in the future, sure, I understand that. I think there have been some very good course corrections that have been made by this legislature, but that's not what this law actually says. What it says is that imagine you live in a condominium association or your constituents live in a townhomes where the roof may be controlled by the homeowners association or the exterior envelope, but the interiors are yours. Well, all of the utility lines run from the foundation through the home. What about a plumbing problem, for example, where the homeowners association owns the underground plumbing, but then that plumbing runs into somebody's home? Both parties have an interest in the outcome of that dispute, and both of them have to be able to work together in order to solve it. Yet what this statute, as written, proposes is that unless a construction component only exists within one of those arbitrary spaces, a homeowners association can't work with its members to solve a common problem that they both own and they both share. This can be worked out, but as written, I'm not sure that it serves the purpose that you want, and it handicaps a community's ability to solve problems that both interested parties do own. Now, I really liked Senator Orenshaw's questions about whether he really believes that these changes are going to affect anything with respect to insurance premiums, and the question was asked more than once. We have been here before this panel on any number of occasions making modifications to NRS Chapter 40, some requested by the builders, some requested by others. And each time this question gets asked, but we never hear from anybody in the insurance industry willing to give a straight answer to that question. Now, I accept the logic that, I guess, if you immunize contractors, and immunization is a strong word, but if you reduce the homeowner's rights to only a certain period of time, and you make it so difficult for them to prosecute claims, and you redefine what constitutes a constructional defect such that minimum building code requirements don't satisfy the standard, sure, I guess it comes to reason or stands to reason that insurance premiums are going to go down. But they're not going to go down because builders are making repairs. They're not going to go down because the process is any easier. They're going to go down because you've prohibited a good number of Nevada homeowners from prosecuting legitimate claims. So that's a perspective that I'd like you to consider when we talk about that. So I can't say that I speak for all Nevada homeowners, just a large number of them that I've represented over the years and some that I represent now. But we'd be happy to meet with the proponents of this bill on short notice if necessary to discuss compromise and amendments that we believe might be able to satisfy everyone. I think there's a lot of room to be made. But in its present form and the manner the bill's been presented, a few days' notice to Nevada homeowners, which is probably part of the reason that you're only seeing me here, we oppose those parts of the bill that we mentioned. And again, our ordinary course of action would have you talk to homeowners, not lawyers. I understand. But in 3 days, not possible. So those are my statements, and I'd be happy to address any questions that you have.
Thank you, Mr. Reedy.
Thank you.
Actually, you are the only person signed up to testify in opposition to the bill, and there's only one other person who's even signed up against the bill other than yourself out of 32 pages of people. So I actually owe the audience an apology. I thought there would be a lot more opposition testimony, but in fact, there is almost no opposition to this bill. There are only 2 people even signed up against the bill. So if there are questions from the panel for Mr. Reedy, Senator Ford.
Thank you again, Mr. Chairman, for the indulging me with questions. You know, the numbers you just spouted off sound interesting, but as Mr. Reedy has said, 3 days' notice is kind of hard to get people up here. That said, you know, make no mistake about it. I disagree with some of the things that you've said, and we'll get to those in a second. But you mentioned that this is a trade. It's not a trade. This is a cram down. Let's just talk about what it is. You know, I've heard it referred to as the Homeowner Protection Act. It's the Homeowner Rejection Act is what I'm viewing this as at this point. You know, I've received hundreds of emails from home builders, and I've responded to every single one of them. Every single one. And I've told them the exact same thing. This does not have to be a partisan issue. In fact, ever since last session, I've tried not to make it a partisan issue. But the operation that has taken place over the course of the last few days makes this, in fact, a partisan issue. There are several provisions in this version that need to be addressed. And I would hope that this body would entertain that discussion that you've made yourself willing to engage in. And I, too, as I always have, am willing to put myself on the line and help resolve some of these issues as well. So I just wanted to put that on the record, make it known that this is a cram down, not a trade, and we need to work toward trying to fix this between now and you know, the near future, I suspect, but still.
Thank you, Senator Ford. Mr. Nelson, you had a question?
Thank you, Mr. Chairman. I'd like to ask, is it Mr. Reedy?
Yes, sir.
You mentioned the tens of thousands of clients you have. How do you usually get them? Do they come to you, or do you solicit them through some of the form solicitation letters like are shown up on Nellis?
No, I guess I'm the exception to the rule. Most of my clients come through referrals from professionals in the industry. For example, a homeowner might approach their board of directors, or they might approach a community manager, or they may know a friend. And that's typically the way that I do it. But I do understand, and to be completely honest, there are others that do blanket with solicitations, and they do advertise. That's not typically the way that I've done business, however.
Can I have a follow-up? Follow-up?
Yes, go ahead.
Are your clients usually the individual homeowners, or do you represent homeowners associations?
Well, remarkably, it's both. And an individual homeowner isn't necessarily an ordinary person. It could be a trust, it could be a corporation, it could be an investment company, it could be people like that. But ordinarily, it's single-family homeowners, in some cases, community associations and others. Those are the typical clients that I represent.
Thank you.
Mr. Orenshaw?
Thank you very much, Mr. Chairman. Pointing to section 17 on page 20 through 21, I wondered if you could relate to the committee what's been your experience with homeowners where there's been willful misconduct, where there's something like what's being struck in at the top of page 21. How long have you seen the time elapse from when the homeowners discovered the problem? And has it been longer than 6 years? Have you seen cases like that? And if section 17 passes as is, and the homeowner discovers something in the 7th year, what remedies will be available to the homeowner under this bill should it become law as it is?
The best answer is that oftentimes defect lay manifest or latent within a home and don't actually show themselves for many years after the original construction has begun. So typically you don't see the kind of property damage that's now been integrated as a component within the constructional defect definition until the home's been around for a little while and may have gone through some seasonal changes, 4, 5, 6, 7, or 8 years. So the cutoff point at 6 years is probably going to eliminate a number of legitimate claims, a large number of legitimate claims that people won't discover, in my experience, until far after that 6-year period.
Brief follow-up, Mr. Chairman.
Yes.
So should the problem be discovered after the 6-year period in Section 17, what remedies at all would be available?
There wouldn't be any.
Thank you.
Mr. Anderson, then Mr. Wheeler.
Thank you, Mr. Chairman. Mr. Reedy, I wanted to get your impression of this. I mean, odds are, if something passes this session, the judiciary is going to be called on to, obviously, to interpret these provisions. Do you think that 2.5 hours will be enough to vet and explain the intent behind these provisions? Is 2.5 hours going to be enough to explain to the judiciary what this bill does?
Not if you want to hear from your homeowners, the people you represent, no. Now, I could explain it as a lawyer as quickly as I have and put it in simple terms, but if you want to understand what impact it's going to have from homeowners, you might doing it in 2.5 hours is very, very difficult to understand. It doesn't make a whole lot of sense to me. Again, as Senator Ford pointed out, this process is rather remarkable in the manner in which it's proceeding. And that's part of the reason that you see me standing alone here today, by choice.
Mr. Wheeler?
Thank you, Mr. Chairman. Mr. Reedy, I'm wondering why it's so hard to get opponents for the bill here in 3 days when we're filling this room, all of the Las Vegas room, and 2 overflow rooms with proponents for the bill, and they came in 3 days.
Well, they didn't receive notice of this bill 3 days ago. Apparently, according to counsel, they've been working on it for several months and orchestrating their presentation for you here today. I'm pretty sure it took longer than 3 days for them to orchestrate the presentations that you all saw here today. But the real answer to your question is that I'm not sure that I would want to put somebody in front of you who hasn't had a fair opportunity to digest the bill and discuss it. It dropped on a Thursday or a Friday, and today we have it on a Wednesday. That's rather difficult to do or to expect from a homeowner. It's a rather complex legal matter that needs time to digest, and we simply haven't been given that time to digest it. Yeah, there are a lot of people that we probably put in front of you, but in order to digest the interests of bipartisanship, as Senator Ford pointed out, or to get into the nitty-gritty of what the law means, I'm not exactly sure that that's going to change anything.
Ms. Diaz, then Senator Roberson.
Thank you, Mr. Chair. Mr. Reedy, this is a very complicated bill, and the subject matter that it addresses it's very heady and very intense. And as I was trying to decipher it and read it for myself, I kept asking myself, where is the Nevada homeowners' access to justice in this bill? Because I kept hearing the one side of it, but I didn't really see where the Nevada homeowner fit, what was their recourse, what were their avenues that they could take. For example, in Section 3 sub 3, it talks about the time limits in which the homeowners are made an offer and they have to accept the offer, but then there's no recourse that's stipulated. So what if the homeowner doesn't want to take the offer? In what time frame then do they have to live with this construction defect in a home that's probably not functional? And how much time can then that process be dragged out? So my concern again is, where are we leaving the Nevada homeowner?
Well, what this bill does is it makes the preliminary process before a person has access to justice a constitutional right that shouldn't be barred by these kinds of impediments. It takes a process that should take place in, say, 6 months, and turns it into a year or a year and a half. Again, the new warranty process, who knows how long that's going to last, because there's been no time limits placed upon that process at all. Now, we have existing timeframes that are placed that compel people to do things once a notice is provided to a contractor, and I guess we have some reasonable constraints that that process could last no longer than a year. But now we're talking about, what if the process doesn't work? You're a year and a half out now from the time that you originally brought your claim to the attention of the warranty company or the builder before you can even step into a courtroom. I'm not aware of any other citizen that is being told by their government that they cannot process or have access to free public court systems for that long. It just doesn't seem to make a lot of constitutional sense to me. And it's been of some concern to our Nevada Supreme Court and some of their opinions, even taking a look at the more modest provisions of our existing law. And I have serious concerns that, given the mounting impediments that are being placed on this law upon a homeowner's, they have to make even more specific claims. They have to pledge loyalty oaths with this verification. They have to stand out in front of their homes. They have to prosecute warranty claims. You know, any one of them standing by themselves probably won't bother you. But when you start putting them all together and you see what impediments there are from somebody stepping into the courtroom for the first time, it begins to raise some serious constitutional concerns about access to justice. So I'm concerned about that as well.
Senator Roberson.
Thank you, Mr. Chairman. Hello, Mr. Reedy. How are you? I'm over here.
Thank you, Senator.
Appreciate your testimony today. You've spoken at length with regard to your concerns for Nevada homeowners. I'm looking at your law firm's website here, Canepa, Reedy, and Rubino, wherein you boast of having recovered $407 million in construction warranty claims, the most of any firm in this state. I'm just curious, how much of that $407 million has gone to your law firm in legal fees?
First, let me correct the record. That's a former old website. The name of my law firm is Canepa, Reedy, Abley, and Costello, and we've recovered well in excess of $700 million on behalf of Nevada homeowners and helping them prosecute their legal rights, and we're very proud of that record. And yes, a portion of that was paid by the builders' insurance companies as legal fees. And in each case where I've presented my legal fees pursuant to NRS Chapter 40 to the court, which will only approve those fees if I prevail in an action. The word entitlement, by the way, is a misnomer. There is no entitlement to attorney's fees under NRS Chapter 40. It simply provides that if I prevail in an action at the time of trial, that a court may, in its discretion, award me attorney's fees. It just allows for that, because under the typical American rule, absent a contract or a statute, I'm not going to be entitled to those, or perhaps an offer of judgment. So yes, a significant portion of that number, Senator, were for reasonable attorney's fees. But again, we live in a free market economy, and you know.
No comments from the audience,
Mr.
please.
Chairman, could I just follow up really quickly?
Yes, Senator.
So thank you for correcting me.
But I wasn't finished.
Let me just finish my question, and then you can answer all of it.
You got it.
So it's over $700 million. Ballpark, 40% of that, $280 million?
No, far less than that.
Far less, 30%, $210 million?
Probably a little less than that, too.
A little less, but pretty close?
But you're pretty close, sir.
Okay, thank you.
Now, to finish what I was going to say, however, is that has enabled tens of thousands of Nevada homeowners to have access to free public justice against all odds. Now, a reference was made a little earlier to a case, but you weren't told everything about that case. You were told about a case going to trial, I think it was a year and a half ago, because I took it to trial along with others. And the attorneys were awarded millions of dollars for their efforts. But what you weren't told is that NRS Chapter 40 notice was given to the manufacturer of that defective product long before any of those attorneys' fees had been incurred. That manufacturer decided to make a stand. They decided to prove a point, and they lost. And you know what? They probably spent double that amount of money trying to pound those homeowners into the sand over a $600,000 demand. They could have come out and fixed that problem, and there wouldn't have been a drop of attorney's fees. But what they decided to do is draw a line in the sand and use their overwhelming economic power against those people. And we spent 6.5 months in a trial, and a jury of Nevada peers came out with that decision. And the judge, exercising her discretion, awarded those attorney's fees because she saw that that was the only way that those people were ever going to get justice. That's the case that I remember.
Any further questions? So, oh, I'm sorry. Oh, please, Senator Brower. Nobody else does at the moment.
Thank you very much, Mr. Chairman. Mr. Rita, thank you for being here. I have to just emphasize, though, that this 3 days excuse is a bit curious to me. I have received hundreds of emails, and we, as Mr. Wheeler pointed out, have rooms full of people. And so if it was intentional, as I think you suggested on your part, that you be alone today, that's fine. But let's not suggest that nobody knows what's going on. In fact, I think the world, at least the world that is involved in this hearing, has known for months that there would be a construction defect reform bill of some type this session. And apparently there have been negotiations and discussions, and believe me when I tell you that I have more meetings on my schedule than I can attend, and I'm not inviting any more. But I've not been approached by a single person who is opposed to the bill, to the concept of reform, or to the idea in general. Not a single person has asked for a meeting, has met with me, has expressed any dissatisfaction or concern whatsoever. And so the idea that this is somehow a partisan bill and someone's being ambushed here and it's unfair to homeowners, I got to tell you, that just has not been my experience over the last 3 or 4 months, and certainly not over the last week. But let me ask you about some provisions of the bill that you highlighted for us. And in no particular order, you mentioned Section 3, the offer of judgment provision. And you suggested, Mr. Reedy, if I understood your testimony correctly, that who is going to explain to the homeowner what an offer of judgment means? Well, isn't it true, Mr. Reedy, that that's your job, just like it's the job of the lawyer for the home builder to explain to the home builder client what the offer of judgment concept means? Isn't that the plaintiff's lawyer's job to explain it to the homeowner who is contemplating filing a claim or who has filed a claim?
So now we have 2 things to look at. Number one, when NRS Chapter 40 was originally enacted, it was so that homeowners wouldn't need to hire lawyers in order to prosecute the claims. So 50% of the people you're talking about don't have a lawyer in the first place.
Now, Mr. Reedy, let me just suggest to you that that would be a great system, and we may not be here but for the irresistible gravy train that the plaintiff's lawyers saw with Chapter 40. That's why we're here. I mean, $740 million, I think was the number, in recoveries, and the percentage that you acknowledge going to the lawyers, that's more than 5 times the annual budget of the State Department of Public Safety. It's just staggering. It's just staggering. But my question again is, you questioned the workability of Section 3 because you posed the rhetorical question, who will explain to the plaintiff how it works?
Correct.
And again, my pointed, specific, narrow question to you is, isn't that your job?
Assuming that this bill allows homeowners to retain lawyers.
Why wouldn't it?
You're taking away their entitlement to reasonable attorney's fees. They're going to have to pay somebody out of pocket. If you've got a roof that takes $1,000 to fix, that's a lot of money for somebody. But to walk into a lawyer's office and pay them a retainer, even a modest one, cuts into that recovery for them.
Mr. Reedy, you know that when you engage clients like this, you don't require them to pay a retainer. You tell them that they don't have to pay you anything, and until and unless you recover for them. Isn't that how it works?
That's how it works under the existing law.
Okay, and why wouldn't it work like that under this proposed change? And let me qualify that with one further question or comment. It's true, isn't it, that when a homeowner recovers under Chapter 40 by way of settlement or judgment, that the homeowner is not required to spend any of that money on repairs. Isn't that true?
That's correct. And if somebody's involved in an automobile accident, and they recover money for pain and suffering, but they haven't been able to pay the bills to stay in their own home. They have choices to make, I understand that. But we always recommend that our clients use the funds to make repairs.
But there's no requirement that they do so.
Only
And
if they choose to ignore the advice of counsel, then I can't stop them from doing that, because just like yourself, I don't tell you what to do with the money that you get, because I don't know all the priorities that exist in your situation. Do you have rent to pay? Do you have children to feed? Do you have child support? I don't know. And so I don't know. But we always recommend that they use the money for the purpose for which it was intended.
That's right.
All right, Senator, we have limited the questions, so you want to wind it up?
I do have a few more.
Go, all right.
Thank you very much.
All right, Mr. Anderson also has one, though. So, but in fairness to the people on the committee, we did try to limit the testimony or the number of questions that were going to be asked. But since he is the only witness that's going to be here today on this, go ahead, Senator.
Thank you, Mr. Chairman. Section 8, Mr. Reedy, you mentioned you have a problem with Section 8. I think you described it as being punitive, and I don't. And without to the chairman's point, I really don't want to open this up to another 1 hour long soliloquy full of exaggerated hyperbole. I really don't want to do that. But what exactly do you think is punitive about the I think reasonable requirement that a homeowner at least acknowledge that he or she has the alleged defect in their home, that they're aware of it, they can see it, not that they can articulate with expertise exactly what is causing the defect, but simply say, yes, I have water damage in my home. What's punitive about that?
You left out the part about subject to penalties of civil and criminal contempt.
Well, why not? If someone's going to lie about that fact, why not subject them to some kind of penalty?
I'm not sure if I made this analogy before, but imagine the situation where you're sick and you go to see a doctor. Do you really think that a regular or an ordinary homeowner understands all the reasons that they might have to be, that they have to certify in advance under penalties of criminal or civil conspiracy or perjury, whatever you want to call it, that they have a particular type of illness before they can get their builder out to fix a home, before they can get their doctor to see them? I just think that smacks of a punitive nature.
Well, Mr. Reed, I just have to differ with you on that as well. No one goes to the doctor with an expectation on the part of the doctor that the patient can articulate with expertise exactly what's wrong with them. You go to the doctor and you say, it hurts here, okay? And that's all we're asking of the homeowner, is to acknowledge that, yes, I have a problem in my home. It's not an idea that some plaintiff's lawyer cooked up and suggested I say on the record, but I'm actually swearing that I have a problem as vague as it may be, as general as it may be, I have it in my home. So again, I just don't see anything punitive about that. Mr. Chairman, to your point that we have limited time, one more question, then I'll rest for now.
Wind it up with one, and we'll go to Mr. Anderson.
Section 20, you pointed out, Mr. Reedy, yes. If I understood you correctly, and please correct me if I'm wrong, you seem to suggest that because of the proposed change to Section 20, a problem with what you might call common issues or common infrastructure couldn't be brought on behalf of an association, but the final clause of subsection D reads, unless the action pertains exclusively to common elements.
Correct.
So I'm wondering if maybe you can just clarify that for the committees.
Perhaps you can clarify for me, and we can help each other about what the term exclusively means in that particular statute, because as I pointed out before, some of these construction components thread through both common areas and within individual unit areas, and they're shared in common by both sets. Now, if this law says that a homeowners association can only bring a claim when that construction component exists exclusively in some arbitrary airspace defined by the covenants, codes, and restrictions, then you're shutting a homeowners association's right to fix their own property out. That's the way that I saw the term exclusively, because it's that term which gives me the most concern.
Well, I appreciate that attempt at clarification. I have to respectfully disagree with you. And I'll say just finally, Mr. Chairman, I think that's a great example of the problem that has brought us to this point. That in the past, common sense efforts to reform Chapter 40 have been met with just efforts to obfuscate and exaggerate and just distort what the reform efforts are all about. With all due respect to my colleague from the Assembly, This is not complicated. I deal as the chairman of the Senate Judiciary Committee with bills that I believe are very, very complicated. I try to look at them with a layperson's point of view. And yes, we deal with some complicated issues, and it's challenging, even for the lawyers in the body. This is not a complicated problem. This bill, in my view, is not a complicated solution. And I commend you on what would have been a great closing statement in a trial. But frankly, that kind of rhetoric doesn't help us here. We're trying to solve real problems for real Nevadans. And frankly, again, I'm a little surprised that you're here by yourself, that no one has asked to meet with me. I'm not inviting a line out my door, but I'm happy to talk with you or anybody else in detail, the kind of detail we don't have time for today. But wow, this has been unpersuasive, to say the least.
I thank you, Senator. I accept your
Thank you, Mr.
invitation to
Chairman.
meet and discuss the bill.
All right. Thank you very much. We got several people that want to ask some questions. We'll start with Mr. Anderson, then Senator Keywen, then Mr. Orenshall.
Thank you for the second question, Mr. Chairman, for this witness anyway. So we've heard a lot about attorney finances, and truth be told, I don't think there's any attorney on any side of the bar that gets into law so that they can't make a lot of money. So I think it's only fair, since we've heard about the plaintiff's bar and how much the plaintiff's bar makes. I mean, do defense lawyers make a good living as well, representing home builders?
Yes, but I don't want to, I agree with you that the point really isn't, this isn't about me. This is about Nevada homeowners and what's best for them. And that's where I think the argument needs to be. Of course, the lawyers that lined up here today, the 12 or so people that we saw, they're all getting paid to be here and say what they have to say. But I don't want the argument to focus on them. I don't want the argument to focus on me. I'm here to focus on the rights of Nevada citizens, and this is a bad bill for them. Strip me of it. Strip me of it. It's just a bad bill for Nevada homeowners, and that's the point that I want to make. It's not about me.
Senator Keywen.
Thank you, Mr. Chairman. I've been sitting here quietly listening to both sides of the issue. First of all, I think it's incomprehensible to me why we're speeding up this process. I've been here 5 legislative sessions, and this is the fastest I've ever seen a bill get through. That's not how you make important piece of legislation here in the legislature. It's incomprehensible to me. This is a policy that we're trying to establish long term. Inevitably, in 2 years from now, 4 years from now, we're going to be back here at the legislature. And we're probably going to be dealing with this issue once again, regardless of what happens here. I want to see a long-lasting piece of legislation get through, a bipartisan piece of legislation, a piece of legislation that's been compromised on, that's been talked about with both sides, that's been debated thoroughly like we have today. That's how we've done the job here at the legislature. I've been here since Bill Radja was here, since Barbara Buckley, when they used to sit down and give it weeks before we can make a final decision. And it's incomprehensible to me why we have to do this on the second week, on the third day, regardless of how you feel about this issue. Obviously, it is a very complex issue. It is a tough issue for a lot of us. But at the end of the day, look, we're here to protect our constituents. We are here to represent our constituents. And with all due respect to the chairman of Senate Judiciary, this is very complex stuff. You try explaining this to my constituent, Maria Perez on 28th Street, and I guarantee you she will not understand this piece of legislation.
All right, Senators, our question.
So
here's the reality. All right,
yes.
this is a hearing. Okay,
Yes,
we're not
Mr.
calling for a
Chairman.
vote.
Well, I
We
was
still
getting
have
to my
other
question.
opportunities on the Senate and our side to do things. So
Thank
this
you,
is
Mr.
not like
Chairman.
we're the final of everything that like everybody's talking about. This is a hearing for this bill.
So I was getting to my question, Mr. Chairman.
So please,
my
question quickly, because we got 3 minutes and that hour's up for the opponents of the
Thank
bill.
you, Mr. Chairman. I would hope that you give us the same amount of time that you've given your colleague.
I've
the
given
chairman
a
of the
full
Senate.
hour to both sides already with only a single person in opposition to
Mr.
the
Reedy,
bill.
my question is, how much compromise has there been on this bill? How much work, how accessible has the other side been to some of your possible amendments or your suggestions?
Not much at this point, but I do believe that we have begun to open the dialogue. I'm just hopeful, as you said, that time will be given to this complex matter, a sufficient amount of time to bring all interested stakeholders, particularly the most important ones, Nevada homeowners, to the table. Because I believe that this bill, if we do what you recommended, I think it can be a win-win for everyone. But that's just not the way it's happening right now. But again, I don't want to close the door on further dialogue. I want to open it. And again, we're willing to meet with you if you're willing to meet with us. Thank you, sir.
Before I got to say one thing on that. As chairman, I've been involved in this issue, not as chairman, obviously, but as a legislator. And the idea that this has not been thoroughly vetted, we have been denied, the people that are proponents of this bill have been denied even a hearing for at least 2 full sessions. The last hearing we had was held when I made the request to Chairman William Horn in Judiciary 2 full sessions ago. So the idea that everybody wants a bipartisan opportunity to solve this problem has been absolutely denied to those of us who are proponents of this bill for at least 2 sessions. So I don't accept the idea this is some new out of the blue thing, that there is this unfair factor that's being applied, because it just isn't true. In fact, this is the first fair opportunity that the people sitting in this audience have had for at least 4 years to even have an opportunity to vent their concerns. So I want that on the record right now. Mr. Orenshaw, and then Mr. Anderson and Mr. Thompson, but make it quick because we're winding this thing up. Oh, you don't have any? Okay. Mr. Orenshaw, go ahead.
Thank you very much, Mr. Chairman. Mr. Reedy, earlier Senator Brower talked about Section 8, subparagraph D, the sworn statement under penalty of perjury from the homeowner, and he talked about needing that due to trying to prevent a plaintiff's attorney from cooking up a claim, getting together with the homeowner. Aren't there already serious penalties from the courts and the Bar Association for any plaintiff attorney who might attempt to do that? I wish you would talk about that and discuss that.
The answer is yes. And if
Mr. Perry, your microphone on. I'm sorry, they've asked me to.
Yes, I believe the microphone's on.
Very good, thank you. Sorry to interrupt.
The answer is yes. There are laws and procedures in effect for penalizing people who file frivolous claims or lawsuits.
A brief follow-up, Mr. Chairman.
Very brief.
And they can result, am I not correct, both in fines from the court up to and including penalties from the Bar Association up to and including potential loss of the ability to practice, correct?
That's just for the lawyers. I'm also talking for protections that are built in place if an owner or a litigant who brings a claim to court that they know to be frivolous. There are significant penalties for those people as well.
Under existing law. Thank you, Mr. Chairman. Yes. Thank you.
Mr. Thompson?
Thank you, Mr. Chair. First of all, I just want to state that I've been quiet because I really wanted to take in, I was really looking forward to having the bill completely walked through. It's incumbent upon me as a representative for my constituents to make sure that I have as much information as possible and that I understand that information in order to help them. My question, I have a lot of questions, but I'll only do the one, is on Section 8. Again, kind of piggybacking on about perjury, and it's stating a lot on the homeowner. So I'm wondering, where is the balance with the home builder and or the subcontractor as far as perjury is concerned, or as far as denial of claims and so on and so forth? Where do we see that balance for constituents' sake and on both ends?
Well, actually, there's very little balance in this bill because there's very little consideration for what the homeowners need. You make a pretty good point, and we've advocated for some time that there probably should be some sort of a homeowner bill of rights, a certain minimum set of standards that homeowners can expect from laws like this, minimum requirements for access to justice and access to a right to trial by jury. And all of the, it's kind of like the golden rule principle, Assemblyman Thompson, is that if the shoe were on the other foot and we had such oaths that had to be taken by contractors that they would participate in the process in good faith, by their insurance companies that they would participate in good faith, then I think you would hear a lot of the same arguments that I'm making. So the balance is missing. What we're seeing here are some measures that are making it more difficult, expensive, and burdensome for the homeowner to prosecute a claim, but there doesn't seem to be any further carrots or sticks with respect to a developer or a builder's conduct with respect to the process. We heard today that builders are denied the right to repair, but I've got to tell you, I have presented any number of notices, hundreds of notices to builders. And you know the first thing that happens? They turn it over to their insurance companies. And insurance companies are not in the business of making repairs. They just won't do it. There are cooperation clauses in the contracts that bind or tie builders or contractors. Where are their concomitant obligations to homeowners to act in good faith? There's a little balance that's missing.
Okay. Thank you so much.
Thank you, sir.
Mr. Is there anybody else here to testify in opposition to the bill here or down in Clark County? Mr. Reedy, I think you're all alone. You may be all alone in another respect. Is there anybody else here whose firm or business has made over $200 million in construction defect? I don't see any. You're all alone. All right. Well, thank you. Is there anybody else who would like to testify in favor, or excuse me, in opposition to AB 125? Seeing none, is there anybody here who would like to testify in the neutral position? Clark County, is there anybody down there that would like to testify in the neutral position? Clark County, I've neglected you. I would like to make one request. For those of you in the audience in Clark County that are in opposition to AB 125, would you please stand up? All those that are in favor of AB 125 in Clark County, would you please stand up? Same thing in the north. Anybody in opposition, stand up. Is there anybody here who are the proponents of the bill who want AB 125 to pass? Would you please stand? Okay, thank you very much. Thank you for standing up there. I think that honestly says a lot. Is there any public comment? Well, this time I'm going to bring back up Mr. Hicks. If you would come back up for one brief summary for any. Thank you, Mr. Reedy. I'm sorry I didn't let you go on that. Mr. Hicks, is there anything, quick rebuttal or anything you want to do? I'll give you the last couple of minutes of the hearing here.
Thank you, Mr. Chairman. Josh Hicks for the record. I will be very brief. I think this committee has heard both sides and heard this bill. We're certainly always open to any discussions or further discussions from any committee members. Please reach out to us and we can explain this in some more detail. This is something that is considered long overdue by the home building industry. We think this will restore Chapter 40 to what it was originally intended to be, get homes fixed, improve jobs, improve the economy, and that's why we're supporting the bill.
Thank you, Mr. Hicks. Is there anybody here? Well, I am going to close the hearing now on AB 125. Oh, I'm sorry, Mr. Keywan does have a comment. Please, Mr. Keywan.
Thank you, Mr. Chairman. Josh, just want to say thank you for your presentation. And would you be willing to continue talking to the opposition of this bill in the coming weeks to make sure that we come to a good compromise bill that could be long-lasting policy?
Senator Keywan, Josh Hicks for the record. We've always been open. I've been doing this for about 3 years. The first time I've been approached by the opposition on this was 60 minutes before this hearing.
Okay. Mr. Araujo has a question also.
Thank you, Mr. Chair. Mr. Hicks, I just had a follow-up comment in regards to my previous question in regards to constituents or homeowners attempt to recover for their loss should the defect be too severe that they have to find alternative housing. And I just want to put it on the record that I was looking for more of an understanding of how the homeowner would actually get recovery if the case were not to be entered or the claim were not to be entered into Chapter 40. I wanted to see who would be financially responsible for that burden.
Assemblyman Arroyo, Josh Hicks for the record. If you're talking about if it was outside of Chapter 40, a warranty claim or something like that,
correct.
I suppose it would depend if the warranty covered that or not. I think that would probably be the first place to look. The contractor's board, if it goes through the contractor's board process, they have the ability to award up to $35,000 to somebody out of the residential recovery fund. So I think you could look to that as well. There are other options to try to do that. And I think that's where you would be looking for those things.
I appreciate that. And I just, moving forward, I would like more clarification on behalf of what the homeowners have to look forward to or may not have the right to should this bill pass.
Okay, two final questions, Senator Brower and then Senator Jones.
Yeah, thank you, Mr. Chairman. Just a clarification. I referenced In response to a number that was thrown around, I referenced the Department of Public Safety budget. And so let me just clarify for the record in case I misspoke. The total estimated amount of recoveries from construction defect litigation, it has been $2 billion. That number is more than 5 times the annual budget of the Department of Public Safety. So I think I misspoke earlier. Just want to make that clear for the record. Thank you, Mr. Chairman.
Thank you, or Senator. So let me get that straight, though. So you'd multiply that by 40% to indicate what the take was by a typical law firm, since you're a lawyer and I'm a plumber?
Well, let me clarify. Thank you for the question. And you're a good plumber, Mr. Chairman. I think I'm putting at least one of your children through college with the fees I've paid your firm for plumbing services in the last few years.
$25,000 water heater. What do I say? Sorry.
But it was a discount from $50,000, so I appreciate that.
I only kept 40% too.
Mr. Chairman, I don't purport to know the details of exactly how each and every construction defect plaintiff's lawyer is paid, but my understanding is that the typical 30 or 40% contingent fee is not the norm in this context, and rather that in the typical, and Mr. Hicks will correct me if I'm wrong, in the typical construction defect case under Chapter 40, oftentimes the attorney's fees exceed what the homeowner recovers. It's not a fraction of what the homeowner gets, but it exceeds that amount. And Mr. Hicks, if I'm wrong about that, please correct the record.
Senator Brower, Josh Hicks for the record, that's correct. We actually put into the record a recent order, so it's in Nellis for you in a Chapter 40 case. That was one of the ones that was discussed there. And in that case, I think it was about 16 times difference between what the homeowners got and what there was on attorney's fees costs and interest on attorney's fees. So we put that in because we wanted to show an actual record from the court. That was a case in, I believe it was January of last year.
And Senator Ford, we'll have you wrap it up.
Thank you. You called me Jones, man. You said
Did I? I'm
Jones
sorry.
earlier.
I apologize.
Okay. I'm used to that. I used to get it all the time last session. You know, it's clear to me that based on this last conversation, to some folks, this is not about the homeowner. It's about attorney's fees. Recall, you can't recover the attorney's fees that way unless you win in court, which means there was a defect, which means homeowners were taken care of under that circumstance. Now, let me back up something. I just want to be sure that the record is completely clear. You said that you heard from the opposition to this bill 16 minutes before the hearing. You and I have been working on this for almost a year, Mr. Hicks, and I approached you the minute I found out about this bill on Friday. So it's not 16 minutes before. There are terms in this bill that I agree with, the specificity as an example, the attorney's fees issue we can talk about, but some of these other issues I've been trying. I've spoken to you, I've spoken to the chairperson of this committee, the bill sponsors, I've spoken to as many folks as I could to try to convince you all to come back to the table and let's find a reasonable solution to this. Let's be certain that that's clear and for the record.
Senator Ford, Josh Hicks, for the record, thank you for that clarification. You were absolutely right. My comments were with respect to being approached by the trial lawyers themselves. The first time I had actually heard directly, personally from them was that. Senator Ford, I want to echo those remarks. Senator Ford, you have been nothing but accessible and approachable on this subject. We very much appreciate that. We've endeavored to come up with a strong, reasonable bill, and we're very, very encouraged that you've always talked to us and continue to talk to us on this. So my comment was not directed in your direction at all.
Thank you, Mr. Hicks. With that, we will close the hearing on AB 125, and at this time I'd like to open it up to public comment. If anybody would like to comment on any issue, now's your time. Anybody down south that would like to comment publicly on any issues? Seeing none, we will close this joint hearing. Thank you very much.